My lord.
Serial number 49, my
You want
lord.
to mention?
Yes,
Madam, you want to mention?
yes,
Yes.
we are
Accept.
colleagues.
Yes, yes.
49, my lord. I have some income. My father-in-law is hospitalized.
Pardon?
My father-in-law is hospitalized. I want some accommodation. Serial number 49, man.
Will add it.
Your Lordship, kindly, my lords, on fresh writ appeal, my lords. On fresh writ appeal, the issue was whether the DRT would have supervisory jurisdiction over the functioning of Metropolitan Magistrates Court.
It will be listed. Once you remove the office of this listed.
Now, what happens, my lord says, I had challenged the virus of Proviso 5 to Section 14 of Surface Act. During pendency of that petition, my lords, the bank has filed an application before the Chief Metropolitan Magistrate for magisterial assistance under Section 14 of Surface Act. There is a conflict between Section 211 and 21J of the Surface Act. After I bring it to the notice of the Chief Metropolitan Magistrate, the daily routine recording proceedings are erroneously recorded. It's all contrary to records. Now that I challenged, on 27th May, an interim order was issued calling upon me to deposit 1 crore. I deposited 60 lakhs. On a return of notice, 2 weeks time was granted to deposit the balance of 40 lakhs with a direction to the bank to release that amount in favor of the bank.
July. Yes.
My lord, matter is urgency. It appeal. We have filed the petition. The senior citizen act before the set aside the deed and sale. That petition was allowed. On the basis of that order, the respondent challenged the writ petition before the Honorable High Court of Karnataka. That writ petition was allowed. On the basis of that reason, the respondent trying to dispose the appellant. Hence, matter is urgency.
No urgency. Yes. Seven. You want time?
Serial number 41, my lord.
Second. What is it? Second August.
Serial number 41, my lord.
Notice has been served. The affidavit has been filed by the respondent actually. Not has to be listed.
It will be listed.
Serial number 41, press time, my lord.
Not by memo.
Serial number 41.
2022 is required to be withdrawn.
Withdrawn.
Because
Get it list.
my lord,
Next wait. No.
wants a relief order from the employer, and that is blocked because of this withdrawal.
Today it can be listed. Wednesday.
Serial number 41, my lord.
Fresh contempt matter, my lords. Learned single judge directed the state to incorporate my name in the RTC. That was not complied. Then I filed the contempt, my lords. In the contempt proceedings, my lords, state assured that they'll incorporate my name within 3 months. Even after the contempt proceedings, my lords, it is not. It's the
Not by-
second contempt. my lord.
It will be listed.
My lords,
Not by memo. Yes.
My lord,
it's a mining case, my lords. The respondent authorities, my lords, has unilaterally cancelled the license, my lords, of the quarry. The quarry was running, my lords. It was stopped from day before yesterday, my lords. Hence, there is a.
You remove the office officer, we listed.
Serial number 41, my lord. Press time. Pressed.
Serial number 8, my lord. That, my
Yeah.
lord, I have filed on appeal, my lord, 188 of 54. The UGC also, my lord, has filed an appeal. That is not connected. Both has to be connected against a single order, same order. my lord.
Serial number 8. This appeal shall be listed with writ appeal.
Serial number 41, my lord. Press time.
954 of 2024. 954 of 2024.
954 of 2024 on 1st August.
Serial number 41, press time, my lord.
41, you are seeking time.
Yes,
Time.
my, yes. my lord,
C1. 13th August.
Lord, serial number 94. My lords, I'm for the appellant in the second list, my lords. I'm seeking a week's adjournment, my lords. I've informed the other side. My lords, just a specific date would be.
Where is second?
My lord, please come on 94, my lords. WA 84.
8040, what do you want?
Yes, my lord. I'm for the appellant. My lords, I seek a week's adjournment, my lords. I've informed the respondent. A specific date will be given, my lords.
My lords, I appear for response number 3 to 9 in this
7th
matter.
August.
My lords.
7th August.
My lords, we had in the next week, my lords, I appear for the respondents in this
My lords,
matter.
respondent,
Yes.
I appear for response number 3 to 9, my lords.
Mm.
May a date please be fixed in the coming week, my lords.
Not possible, Mr. Yes.
My lord, serial number 63, my lords.
Yes, Mr.
79, my lord. Next week.
My lord's matter pertains to imposition of GST on royalty paid on quarrying lease. Matter has not been posted.
It will be posted. Remove the office of this.
Number 79, my lord.
Seven-
Next week.
79. Yes,
My lord, serial number 60,
next week, 2nd August.
serial number 63, my lord. In that matter,
Please.
23, my lords, in the PIL filed by me, my lords, an impleading application is filed. On objection, my lords, it is listed. My only concern, my lords, the impleading applicant have approached the single judge of this honorable court and obtained an interim order against implementation of the orders passed by lordship in division bench in this PIL.
How can it?
It has happened, my lords. Hence, they have come on record also. May I seek indulgence, my lord? This matter may be clubbed along with the single judges, the writ petition, my lord, 18153 of 24, my lord, and called, my lord, because they have specifically, I have even read the order which clearly refers to the orders passed by the honorable your lordships, and in implementation a notice was issued.
We'll
that was-
consider at the time of hearing, you produce that order.
They have filed an impleading application making the very same submission. They have obtained an interim order. They are not in denial. They are present before this honorable court.
appealing for impleading applicant in that matter, my
What do you want but today?
That this may be clubbed along with that, that is the only.
That can't be. You then approach the register judicial. In that way, it can't be clubbed. You file some application with register judicial.
Yes.
And we'll pass some order on administrative side, but not on judicial side in this fashion.
Much.
Serial number 77.
You want to proceed with this, you can proceed. Either way, your choice is yours.
Serial number 77. You have to
70,
note serial number 77.
70.
Notice for R4 is not served, my permission address with email ID. So it may be urgent.
18th August, 19th August. Serial number? Senior is not. Is PIL. About what? Perjury, No hurry. 8th of August. There is no hurry, there is no urgency. 8th August. 8th August.
For pronouncement of judgment, serial number 1, Mr. Arun BM.
Contesting this.
Writ petition is allowed. Respondent authorities are directed to admit the petitioner to the MBBS course on the seat in the quota reserved for sports for the academic year 24-25 without applying any seniority among the candidates eligible for admission under the sports quota in the CET NEET examination conducted for the academic year 24-25. The petitioner shall pay the fees as prescribed for the current academic year. All pending applications disposed of.
My position, my lord, the respondent number 7, the direction, my lord, that my position, quota should not be disturbed.
We are not disturbing.
That, my lord, there was a direction by the apex court. Sorry,
That no student is to be disturbed. You are not to be disturbed.
please.
We'll do that. It is there, but we'll find.
Grateful.
contempt matter, seal number 2, so Janardhan G.
Direction by one single judge, my lord, actually, he takes that.
What is it? Notice returnable on 8th August.
This. Seal number 3, Mr. Sudhindra S.A.
The appellant in this case. So this was heard yesterday.
Yes, ma'am.
We are dismissing it, dismissed. As far as the civil application is concerned, we do not find any case. The court does not find any case to issue the directions prayed for in the civil application. In view of what is held in the, while this, in view of what is held in view of the, what is held while dismissing the main appeal, the civil application is also, interimly also dismissed. Sorry, yes. Dismiss. Next. Blood.
Yes. Seal number 4. Sumoto writ petition.
Respondents 2 to 4, my lord. Five questions that your lordship had raised while taking suo motu cognizance, my lord. Detailed reply has been filed, my lord, placing facts and figures.
You are for?
Respondents 2 to 4, state, my lord.
State.
State. May I take your lordships through the reply, my lord? In fact, additional PCCF is also online, my lord. If a Project Elephant, additional PCCF is also online, my lord.
Additional?
PCCF, Principal Chief Conservator of Forest, Project Elephant. Lord, now if lordship takes page 2, my lord, we have stated Karnataka, lordship got it, my lord, 5A, page 2. I have in fact served a copy to the learned senior counsel also, amicus curiae. It's okay, my lord. Yeah, it's okay. It's okay, my lord. It's okay, my lord. I don't know. It's okay.
What is sagging lines?
Sagging lines, my lord, are transmission lines which sag over a period of time for lack of maintenance, my lord. The pole support, and those are not, there's no regular maintenance by the electrical companies.
But if the
ESCOMs and,
wildlife or any wildlife or any elephant comes into
yes, my lord, in contact with those,
sagging line,
yes,
then he gets electrocuted.
yes, that is one of the areas that where several letters have been addressed to those electrical companies, ESCOM, GESCOM. And if lordship also directs them to be implemented, my lord, they can also file reports to say what steps they have taken to rectify these sagging lines.
Can't you erect a fencing, keeping a distance between fencing and the sagging lines? So fencing itself becomes barrier.
No, these are transmission lines that run through the forest itself. These are transmission lines that run through the forest, and they have to be insulated. And there has to be a regular maintenance. So these maintenance is required to be carried out by this electrical ESCOM, GESCOM, other KPTCL, my lord. Letters have been addressed to them, but we have not got any response to the forest department letters. So if they are also implemented, my lord, they can also file a report before this honorable court to show what steps they have taken. No. Oh,
They're private agency.
No, my lord, HESCOM, all are under the Energy Department. Additional Chief Secretary, Energy Department is arrayed as a party, my lord. Then they can place the reports. Lordship will also see in page 4, my lord, we have said what is the height of the power lines that should be maintained. 20 feet in gentle terrain and 30 feet in steeper areas. That is one of the causes for electrocution. The other is illegal electrical fences, where farmers near forest fringe, you directly take the power and connect it to their fences. And then the elephants come in contact with those fences. Lord, what we would like to highlight is, if your lordship kindly permits me, Lord, in page 6, we have said we have erected physical barriers. Now, the physical barriers are one, if your lordship turns to page 7, my lord, of the reply. We have said we have used railway barricades, my lord. Approximately 332.62 kilometers of railway barricades have been constructed specifically designed to guide elephants away from vulnerable areas. Now, we have produced maps of the two forests, Bandipur and Nagarhole. In fact, the cost incurred to have 1 kilometers of this railway barricade is nearly about 1.6 crores.
The highest population of the elephant is
Is 6,394.
in particular area, or it is generally spread over in the entire?
It's spread all over. In fact, DCF and RF are also present, my lord, of Nagarhole. In fact, what I am instructed is, my lord, Kabini has the largest congregation of elephants in Asia, my lord. In Asia, all the elephants congregate at one particular point of time. It's the largest in Kabini, my lord. The number we have shown is 6,395, which is the highest. Lord, apart from this railway barricades, my lord, we have also erected solar fences to the extent of 3,426 kilometers of solar fences have been installed. There are two types, my lord. One is normal solar fences and the other is solar tentacle fences. In fact, we have produced pictures, Lord, at the lordship sees the May I request your lordship kindly see the photographs we have produced, my lord, at page 60, which shows the railway barricade, my lord.
These railway barricades are made of what?
My lord, these are old railway track, my lord, which are cut. If lordship sees, I have produced the photographs at page 60, my lord. Annexure R3. Even at page, lordship sees at page 62, my lord. It's a bigger picture of the railway barricade.
And the solar Next page, solar
Next.
power fencing
Yes, my lord.
leads to electrification or not?
No, my lord. It does not.
But it when
It's it's not a continuous, it's a pulsative. And 9 volts is what so there can't be death on account of
it
coming in
prevent-
contact with the solar fences.
it prevents the wildlife from crossing.
Yes. And if Lordship also sees, we have also elephant-proof trenches. Lordship sees at page 68. At page 68, Lordship will see the elephant-proof trenches. 67, 66 also, my lord. Lordship will get there's a person standing in the trench, my lord. Give an idea of the depth. Depth is 3 meter at page 66. my lord. This is done to the extent of 2,420 kilometers.
Yes, sir.
The elephant proof trenches. And we have produced the first 2 maps at page 57, which is Bandipur. Lordship sees all along the boundary of the forest. my lord. All these 3 methods have been utilized to prevent the straying of the elephants and other wild animals.
Is
No,
post, there are some gaps.
yes. That's proposed.
What is,
It's an ongoing,
what is EPT?
it's a continuous process that is,
What is EPT?
sorry, elephant-proof trenches. So railway barricade, my lord, solar fencing, and elephant-proof trenches. These are 3 which are implemented.
Are you planning to fill up these gaps or not?
Yes, my lord.
Within what?
All that will be under
It is
time
under-
limit. I need to verify.
It is under process.
It's under process. It's under process. We have given the exact extent of kilometers. Railway barricade is 332. Solar fences is 3,426 kilometers. And elephant-proof trenches is 2,420 kilometers.
They are there, but.
So these are also, Lordship also sees, we have identified, there's also an elephant task force created in 8 districts with significant human-elephant conflict. And these districts are Kodagu, Hassan, Chikmagalur, Chamrajnagar, Mysore, Ramnagar, Banerghatta, and Bandipur. So 8 districts have been identified which have significant human-elephant conflict. So in those areas, my lord, steps are also taken insofar as having anti-poaching camps. my lord. We have rapid response teams and anti-depredation camps. And apart from that, movement of the elephant is also tracked, my lord. Your lordship takes page 10, my lord, or page 9 of the reply. Apart from regular patrolling by 2,733 frontline staff, my lord, Page 9, we have said anti-poaching camps, which are nearly have 1,922 personnel to prevent illegal activities and safeguard.
Camps are periodically organized.
Sorry, my lord.
Camps are organized periodically.
Yes.
What intervals?
No, these are permanent camps. Anti-poaching camps are permanent camps. Only ADC is seasonal, my lord. We have rapid response teams which are also permanent. And Elephant Task Force created in 8 districts. These task forces ensure timely response to conflict situations and safeguard human and elephant populations. The ETF, RRT and ADC comprises of 811 personnel together. At page 10, your lordship will also see elephant movement tracking is also done, my lord. And patrolling staff alert farmers and villages via wireless messages, SMS announcement.
Yes.
Please, sir. This petition was initiated by your.
Would you like to go through the reply and then?
I have gone through. I have gone through.
Look, one other aspect, sorry, if I can. We have also said habitat development. This habitat development works as grassland development at page 11. Habitat development works such as grassland development, bamboo regeneration, and water hole creation with solar pumps are undertaken. These measures restrict elephant movement into human areas and provide necessary resources within forest, reducing the need for elephants to stray. And we have also, there's an interstate coordination committee now between 3 states, Kerala, Karnataka, and Tamil Nadu. This is to provide for exchange of knowledge between the 3 states, my lord. We have detailed it out in the reply again. Apart from that, my lord, radio collaring is also used. When we find an elephant which has strayed away from the forest, radio collars are also fixed on them to study the behavior of those elephants. Movement and use of advanced technology like drone and other warning systems are also in place, like CCTV cameras, which have been installed at strategic points, my lord. And awareness program.
Is there any centralized system to track the movement of the elephant?
There is a centralized system. Can you explain?
Yes, my lord, a centralized system is there. In the dashboard, we can see which elephant is moving in which area. And we can alert the local people there.
Can spot while sitting in a room.
Yes, yes.
In that central room, you can sit and watch where.
Anybody can log in the computer and they can see, my lord. We have provided password and user ID so that they can log in and they can track the movement of each individual.
And there are
The department treat ailing elephants or
Sorry, my lord.
ailing elephants.
Yes, yes, my lord. Yes.
they are captured and treated in
Captured and
camps.
treated.
Whenever detected.
in the camps, my lord. Their elephants are captured, one to treat them. Secondly, it's also in the event of training them to capture other wild elephants.
Yes.
Please.
As per the census of the year 2023, Millard, there are about 27,000 elephants in India, out of which Karnataka has around 7,000, which works out to 25%. Then, Millard, Karnataka has 6,877. As per the census conducted from May 17 to 19 of 23. I have given all these figures in the submission I have filed. I have filed that.
Do you think that this maintaining agency needs to be party? Then we'll invest time to get it at a time.
No, I have one or two submissions I would like to make. Then, there are two types of elephant, cow elephant and the bull elephant. That is the female elephant and the male elephant. My lord could kindly take the figures I have given in the page 2 of the report I have 5 minutes. Page 2 minutes, table I have given. There is one typographical error, that is 6,395. Please, my lord could kindly take page 2 minutes. There is one small typographical error in the first table minute. It is 6,395, not 5,395. In the first table means. Luckily, the elephant population is increasing in here in Karnataka, but the the misfortune is, so far as calf is in the next table, my lord could kindly see, male and female are 7.2, 7.2. Same ratio. Adult comes to 16.8 and 35.3. That is, male is almost half of the female. The reason, Millard, is the male elephant are useful for these smugglers and poachers, Millard. Ivory part, which is not available in the female elephant. The male elephants are killed by the poachers, Millard. In fact, we had one person by name Veerappan Millard who accounted for nearly 2,000 elephants' death, Millard, before he was encountered in 2004. 1810, 2004, he was encountered. He has killed around 2,000 elephants. The elephants, Millard, the male elephant has value, not the female elephants. It is for that reason, male elephants are regularly butchered. Even Ashwatthama, again, male elephant. The reason is they are killed and ivory is removed for that purpose. And I was told that even the bones have value, not just the ivory part, the one. Then, Millard, the range has come like that. Then, Millard, I was just posing question to myself as to whether these elephants are of any use to the mankind. In Kannada, we say, Millard, aane nadadadde dare. That means, when we translate it to English, Millard, it means the path which an elephant takes is the highway, is the road.
Soon.
What is ISCOM?
Electricity supply companies. Electricity supply companies.
Electricity
Supply companies.
supply company of
Karnataka, they are Bescom, Chescom and this one. Chamundeshwari Electricity.
Division wise they have.
Division wise.
Bescom relates to Bangalore, Mescom that is Mysore, like that Chamarajanagar, different places they have.
Bangalore.
Electricity supply company ultimately, yes, see
Escom are
same.
the electricity supply companies of.
ESCOM is Hubli. He's DCF Nagarholem,
Nagarwala Tiger Reserve DC.
Deputy Conservator Forest, Nagarholem.
the forest department works in coordination with this company or not?
No, my lord, we have written letters, but we have not received any response. That's why it was our humble request. If those letters we have annexed at annexure R9 to 12. R9 to 13. Meetings have been conducted. Page 90, my lord. 90, my lord. 80. In fact, 89, lordship will get the translated at 89.
This is energy department.
Yes, my lord.
Forest
It's
department,
addressed to the managing director.
forest department comes in. 90.
R10, my lord, lordship may see. At page 93, the principal PCCF Wildlife has also addressed letter to the managing directors. Safe installation of power lines in elephant habitat at page 93, my lord. Page 93, if your lordship got it, my lord. We have said safe installation of power lines in elephant habitat and elephant corridors in the state. Last para, since the increasing cases of death of elephants due to electric shock is a gross violation of orders of the Honorable High Court in WP number dash, and it has been informed to consider carefully the cases of elephants dying due to electrocution in the state and installation of electrical lines in elephant habitat and elephant corridors in safe manner. ESCOM is Hubli Electrical. ESCOM is actually Gulbarga Electric. G, my lord. Chamrajnagar. Chamundeshwari
Electric Supply Company.
Electric.
Electrical Supply Company. Chamundeshwari Electric Supply Company. So it covers entire state. Yes, yes. They have different circles, your lordship. These are all public undertakings, companies under the umbrella of the energy department. They control certain areas for the supply.
We have been instructed that there's no reply to these letters that we have addressed to them.
Join those companies.
Yes, ma'am. Please. ma'am.
Please, before I proceed on that, my lord would kindly turn to page 39 of their report news. Page 39. That is in respect of Ashwatthama's case itself. Merit after the table minutes. After the table, on 10/6/2024 morning, these dates and time become relevant minutes. On 10/6/2024 morning, Ashwatthama elephant was bathed, given ragi balls, and then left to graze in the forest. In the evening, the elephant was bathed again in the evening, and an attempt was made to feed the elephant with a ragi ball, but the elephant did not eat anything. Later in the night, Ashwatthama elephant was tied, please note that, as usual, and the movement of the elephant was observed until around 12 a.m. in the night. On 11/6/2024, Around 5:30 in the morning, Kavadi Ganesh went near the elephant and saw that the elephant was in a sleeping position. The staff tried to wake the elephant up, but the elephant did not wake up. The staff got suspicious, went closer and noticed that the Ashwatthama elephant was not breathing. The staff informed the headquarters immediately. Later, range forest officer while Hunsur and staff members rushed to the spot and inspected and found that Ashwatthama elephant was dead. As soon as the message was received, direction was given to Assistant Conservator of Forest Hunsur so and so to proceed immediately to the incident spot to further examination of the incident. Wildlife offense case was booked by range forest officer and the inquiry is on the death of Ashwatthama elephant was alleged to be due to electrocution. But after the postmortem report by team of 5 veterinary doctors, it was ascertained that the elephant suffered liver and pancreas ailment and was in poor health condition. Due to its poor health condition, the elephant was not eating well and suffered from weakness. Now please turn to page 120. My lord, could kindly at the end minutes summary is there. Page 120, bottom minutes after the table. Romans 7. No, not that side, no. This side it was maybe page mistake, is that?
What you read was part of their report.
Yes, Miller. That's what the report. Romans 7 summary is there, Miller. I told page number. The carcass, it starts with a mill. After the table, biological test done was in 5. May I just take it up?
No, this is what you read at page 39 is what?
39 minutes.
Part of their reply or report?
Report. No, 39 is the reply. 39 is the reply. Now I am reading from page 120, that is postmortem report. The carcass in contact with the solar tentacle fencing electric line, charred signed epidermal lesion noticed along the trend trip, severely congested pancreas, then circumferential pedicle hemorrhage noticed in the epidermal, then generalized. So ultimately, solar is the cause, Millard. But in the report now they say it is not due to solar. Page 39, they say it is not due to solar. But postmortem report says it is due to solar. And my humble submission is, why should there be solar fencing? Because in the report, they clearly say it was taken to in the morning on 10th. It came back, tied to the tree, then fed with the ragi balls, and then it had a sleep. It was washed till 12 o'clock. It went to sleep, and then permanent sleep in the morning at 5 o'clock. But now they say it is not due to solar. It is due to solar.
Postmortem report is prior in point of time.
Yes, postmortem. But now they say in the report, in the submission, it is not due to solar. That to that extent, there may be some, my learned friend has to clarify. And then Miller, this writ petition is a second innings before this honorable court. On an earlier occasion, this honorable court had an occasion to deal with what am I 2009, Millard, this honorable court had an identical situation, Millard, para 2 at the next page. Very observation, my lord was pleased to observe has come in this. The public interest litigation, unlike other usual adversarial litigation initiated by this court suo motu, based on the press report as to mysterious death of elephants in Mysore forest area, is intended to draw the attention of the executives, their statutory duty and obligation, and also to impress upon the public at large as to their role and contribution for the protection of wild animals, birds and plants in general, the conservation elephants in particular, with a view to ensure environmental and ecological security of the country at large. Then they refer to judgment of the observation. Extremely shocked. That's what my lord was also pleased to observe. Extremely shocked and deeply concerned over the news of death of 4 elephants under mysterious circumstances near Kapsoge in Nanjangud Taluk, and surprised and worried about the statistics that 9 elephants died in the last 7 days and 25 elephants had met with gory death in the last 6 months around Bandipur and Nagarhole National Park. But the authorities concerned are yet to trace any clue for the cause and the said disaster as reported in the press. This court suo motu initiated the present public interest litigation. Then, Millard, they refer to the judgment of the Honorable Supreme Court that is extracted, Millard, in page 6, Millard, just above the line, Millard. The largest single factor in the depletion of the wealth of animal, Millard, paragraph 6, Millard, in that very page, Millard, which I just read, the quoted portion, above the lines, Millard, second line above the lines, the largest single factor, my lord could get it, means the largest single factor in the depletion of the wealth of animal life in the nature has been civilized man operating directly through excessive commercial hunting, or more disastrously, indirectly through invading or destroying natural habitats. Then paragraph 7, Millard. With this note of anguish, we by order dated 7/11/2008 directed the state government and the central government to take the impugned issue seriously, study investigate, collect materials and furnish a report by 14/11/2008 as to the cause for the death of elephants, the lapse on the part of the authorities concerned, the action taken against them for such lapses, if any, for remedial measures proposed to be taken to prevent such disaster in future, the precautions to be taken to protect the wildlife, and so and so. Then paragraph 10, middle of paragraph 10. On 9/4/2009, my lord could get it, means, on 9/4/2009, the government submitted a report and an action plan dated 11/3/2009 called Elephant Landscape before this court, suggesting the recommendations for the short-term as well as long-term measures. Then in 11 and 12, they refer to different types, Millard. Then Millard, my lord could kindly turn to page, internal page 14, Millard, that paragraph 39, Millard. There's the second paragraph from the bottom, 7/11/1997. In the affidavit filed on behalf of the state of Karnataka, this is before the Honorable Supreme Court minutes, it is stated that Wildlife Advisory Board has been constituted, but the date of constitution of the board has not been mentioned. The Learned Counsel for the state prays for 1 week time to file an affidavit indicating the date on which Wildlife Advisory Board was constituted. As regard issuance of proclamation under Article Section 21 of the Act, we find from the affidavits filed on behalf of the states that in the event of the states such as proclamation has not been issued in respect of national parks and sanctuaries, the state governments are directed to take necessary steps in that regard. The same shall be done within 2 months, failing which contempt proceedings will have to be initiated against the state concerned. Then paragraph 9, that is the order passed on 16/1/98. In the state of Karnataka, There are 5 national parks and 19 sanctuaries, but the affidavits that have been filed on behalf of the state, no information has been furnished with regard to issuance of the proclamation under section 21 on the issue of the final notification. As regards state of Karnataka, an affidavit has been filed which shows that the forest department officers have been appointed and 10 weeks time is sought for issuing the proclamation. Time prayed for is allowed. By our order dated 23/98, 10 weeks time was granted to the state of Karnataka to issue necessary proclamation. Nobody appears for the said state to indicate as to what steps have been taken, nor has any affidavit been filed. In the circumstances, notice for initiating contempt proceedings be issued to the Chief Secretary to the state of Karnataka. Personal presence is dispensed. Then finally they give directions, Miller, which my lord will get it at penultimate page, Miller, paragraph 67. Penultimate sheet means paragraph 67. Accordingly, we pass the following order. The report and action plan Elephant Landscape dated 11/3/2009, filed on 12/3/2009. The comprehensive action plan dated 11/3/2009, filed on 17/4/2009 for the conservation of elephants and other wildlife proposed by the state, and the comprehensive action plan on human-elephant conflict mitigation, so and so, filed on so and so by Dr. Basapanavar, so and so. The state are taken on record. The state government shall implement the short-term measures mentioned in paragraphs 8.7.1, so and so, as per the action plan proposed particularly, and shall complete the selection and recruitment process for filling up the vacancies of the staff and flying squads within 3 months from the date of receipt of this order. The state government shall also implement the long-term measures mentioned in paragraph so and so, as per the action plan proposed by the state government within a period of 6 months from the date of receipt of the copy of this order. This court further deems it fit to include so and so, retired so and so, as members of the advisory board for the wildlife. So this order was passed on May 25, 2009. I noticed, Miller, that some more orders are passed. They are not reported, Miller, but it's available in the file. Wherein some more directions are given, but in the present report file, unfortunately, it is silent as to what action they have taken on this, Miller. Specific directions were given. And then, Miller, there is one more judgment of the apex court, Miller. That is 2020-10 SCC 589. Paragraph, page 12, Miller. Page 12, that in page 11, directions of the High Court is referred to. In the next page, Miller, that is page 600, paragraph 4, Miller, no separate individual. Normally, we go by principles of natural justice. There, they said, Miller, it is not attracted in such cases. No separate individual hearing is required to be given to any person, though a mass hearing may be given, as generally given in land acquisition cases, and on hearing such objections, the proposed elephant corridor, including the map containing different survey numbers, should be finalized and be also published at an early date, say maximum within 6 months. Then, Miller, para 22 at page 602 minutes. During the pendency of the present appeals, this court was informed that large-scale construction was underway in the Elephant Corridor in Tamil Nadu. In its order dated 12/7/18, this court had made it clear that no construction is allowed in the Elephant Corridor in Tamil Nadu and directed the district collector, Nilgiris, to prepare and present a plan of action on how to identify the construction that have been made, when they have been made, and for what purpose the constructions are utilized. Then paragraph 38 at page 607 minutes. About 5 lines after start commencement of page, paragraph 38 minutes,
Page number 600 and
607. That is internal page 19.
this hospitality association.
Please, sir. First, yes, please. May I pass on my copy, minutes? Yes, about 5 lines after commencement of paragraph 38. It is undeniable that the state government is empowered to take measures to protect forest life and wildlife falling within its territory in the lights of entry 17A forest and 17B protection of wild animals and birds in the concurrent list, and the power of the state government under Wildlife Act to notify sanctuaries. Then Millard, about 4 lines from the bottom, Millard, as was held by this court in NC Mehta versus so and so, the precautionary principle has been accepted as a part of law of our land. Article 21, 47, 48A and 51AG of the Constitution give a clear mandate to the state to protect and improve environment and to safeguard the forests and wildlife of the country. It is the duty of every citizen of India to protect and improve the natural environment, including forests and wildlife, and to have compassion for living creatures. Now, I pose a question to myself, as to whether this solar fencing is permissible, Miller. Yeah, this is same thing. Yes, same thing. Is it? Millard, in the Madras High Court, Millard, a division bench, I have given minutes. A Government of India order has been referred to, wherein there is a specific direction, solar fencing should not be henceforth fixed.
Show on the next day.
Please.
Honestly, party that we.
Yes, I'll give a copy to him also. Yes. Yes, Milord. We have detailed it out in our reply. The disciplinary action is also initiated. FIR is lodged. Milord, report what I am instructed, Milord. Insofar as the Ashwatthama is concerned, Milord, it was in the camp. It's not in a jungle, Milord. It's in the camp.
And the death is not caused on account of the solar fences. It was already suffering from liver and pancreas. And that's also the post-mortem report. No, the report also says because it had weakness arising out of liver and pancreas also. Solar fences do not cause death. And it's a pulsative, it's like a warning that is done to the elephants.
On a death of elephant reported in newspaper dated 13 June 24. On this for two motor cognizance to pass order dated 14/6/24 in which inter alia the authorities were called upon to respond to the following aspects. And paragraph 10. Senior advocate, each argument was requested to assist supporting capacity of amicus curiae. The few more to proceedings comes up for consideration today. For figures on record. Lie on behalf of number 224 of them. Learned the amicus curiae as expense. Submissions incorporating relevant details concerning the use public interest. While the detailed examination of the contents and submissions advanced by the authorities are postponed to next week of in the reply. It is integrally appointed as the one of the major and probable cause for recurrence of the incidents of death of the elephants were electrocution, is non-maintenance of segging power lines, as also the erection of illegal electric fences at places nearby the sanctuary area.
AAG.
That one of the major issues is to ensure maintenance of these sagging power lines and the electrical fences which are erected to become the barricade for preventing the elephant movements to save their life. We have submitted that learned senior council also submitted that the maintenance of these saving power lines, is the task to be undertaken by Karnataka Power Transmission Corporation Limited, Bangalore Electricity Supply, and other electric companies operating in different regions in the state of Karnataka. It was pointed out that as back as in the year 2020, the Energy Department of the Government of Karnataka, as well as also the Office of Principal Chief Conservator of Forest, Wildlife, Bengal, and other connected offices have addressed correspondence, have addressed letters to the Energy Department and the state and the managing directors of the electric companies, emphasizing about continued maintenance of electrical lines and ensure that the power lines remain at safe, and to ensure that the elephant movement remain at safe distance from the power lines. Correspondence, the copies of the correspondence are produced on record. In this context, where it is considered expedient that details about safe installation of power lines in elephant habitat and elephant corridors, as well as proper upkeep and maintenance thereof, to ensure that they do not become the cause for elephant electrocution, are examined by the court. In order to examine such aspects from the following electric, the below mentioned electric company are required to be like parties to process. In the above, learned name of the student. Request the court to permit to add the following companies as party respondents. One should be Bangalore. Karnataka Power Transmission Corporation.
Yes, ma'am. PPTC.
H is Hubli.
Yes.
J is
Gulbarga, actually.
G. Yes,
Mangalore.
CH-1 is Chamundeshwari Electricity Supply Company. Chamundeshwari Electricity Supply.
Yes, which is, where is the office located? Head office?
Mysore.
Chamundeshwari is at Mysore.
Full stop.
Mangalore, Mescom.
Notice the office is that.
All of them have.
Management is post title joining the above companies as party respondent. Notice to the said nominated parties shall be returnable on 12th August.
All those companies, they have standing councils here. All those companies, they have standing councils here.
Including KPTCL as well as the ESCOMs. Yeah, all
Standing
of them
council
have
have-
standing councils before the
They can be
court.
served.
And as far as the CS Energy Department is concerned, we accept notice. State accepts notice. Energy Department,
Energy Department, not a part.
Chief Secretary, Energy Department. The Chief Secretary, Energy Department is also required party in this.
of Karnataka. Power transmission corporation, Karnataka. Government traditional government.
Standing council.
Standing councils.
Panel councils.
Newly added respondents shall file their responses.
We'll also file our,
So duty means.
we'll also file a response to the Kannada Senior Councils.
Please, Your Lordship. Yes, miss, that's directly in the,
It starts with the poem of Tagore.
yes, miss, Your Lordship.
Lord, I'll file my statement of objections to the other connected PIL also in the meanwhile.
My lord, serial number 39 also relates to a wild elephant that was captured and placed in an elephant camp that eventually died. Maybe directed to be clubbed with this matter, my lord, so objections can be filed jointly.
39.
39.
37, no?
14166 of 23.
I'm sorry, my lord, 39. My lord, statement has been filed in that manner.
Yes.
Keep it on 13.
13th, no? Yes.
Right.
We have a very minimum role to play, but we'll take a stand. I'm getting instruction.
Number 6.
Yes, sir, you have 1416.
TJSR
Appear for the petitioner, Your Lordship. The petitioner herein has filed this PIL
That is also an
for the
excellent matter where I-
welfare of the persons of the Dasarahalli constituency, Your Lordship. In the year 2019, government notification came to be issued that a sum of rupees 570 crores has to be released for the developmental activity, developmental work in Dasarahalli constituency. So, Your Lordship. Your Lordship, so far 32 crores has been released, Your Lordship, by virtue of a court order.
Our brother is rightly saying that you are mistaking the Chief Justice as Chief Minister.
Did I address no, Your Lordship, what has happened is by virtue of an order in an earlier writ petition to consider the, yes, yes,
Before the House.
we have sent 5 to 6 representations, Your Lordship.
That is not our domain. You are a member of.
Yes, he is an MLA, Your Lordship. The petitioner is an MLA. Dasarahalli MLA.
Yes.
Yes.
Member of legislature.
Yes, Your Lordship, yes. But we have sent, I may be permitted to point out to the representations, around 6 representations have been sent in 2024. Till today, the amount is already released. It is in the PWD department, Your Lordship. And even in the earlier PIL, by virtue of an order passed in that earlier PIL, 110.75 crores were released, Your Lordship, out of which 32 crores have been released to the Dasarahalli constituency for developmental work. Still 78 crores are still pending and it is kept in the PWD department, Your Lordship. We are just asking for a mandamus, Your Lordship, for release of those funds. Your Lordship, we have sent so many representations. Where should we go, Your Lordship? May I point out the photographs to Your Lordship of the dilapidated condition of the Dasarahalli, the roads, the old buildings. It is in volume number 3, Your Lordship. The potholes are so deep, Your Lordship. If any two-wheeler were to.
The amount is sanctioned, what is sanctioned? 570 crores is sanctioned.
sanctioned. It was cancelled later. It came to be cancelled, Your Lordship. Therefore, two writ petitions were filed. The first writ petition was dismissed because it was found to be premature. In the second writ petition, an interim order was granted to consider the representation of the petitioners, Your Lordship. After that, 32 crore, 110.75 crores was released. And it is in the PWD department, Your Lordship. In that, 32 crores is already released for developmental work. We're just seeking a mandamus for release of the remaining 78 crores. It has become so dangerous to even travel on those roads in Dasarahalli, Your Lordship. May I take Your Lordship's attention to the photographs? With the kind permission of this court, volume number 3, Your Lordship, I will be able to establish how dangerous the roads are, and tenders have been issued, Your Lordship. Work was started, and while the work was going on, they withdrew the grant, Your Lordship. That is why the petitioners had to approach the court. In volume number 3, page number 1104. Demolition work has taken place already, Your Lordship. I know, connect my. Connect my 2861, 2861. Connect my.
Roads are in bad condition.
Horrible, Your Lordship. If any two-wheelers were to go over that, and if a person falls, hospital, Your Lordship, he will have to go to the hospital itself. Roads are in bad conditions, and several old buildings have been demolished. Tender works have been given out, but the funds are not released. One other information, Your Lordship, in the earlier writ petition that is still pending, Your Lordship, since we had to file all additional information and additional documents, that is why this has been filed. This may kindly be connected with the earlier writ petition, Your Lordship, and notices may kindly be issued to the government, Your Lordship.
The chief minister's Nagoradhana scheme is different.
Your lordship, this is not, it comes under the same scheme, your lordship. Several wards were given funds, your lordship. Several wards were given funds, but Dasarahalli grant of funds was cancelled, your lordship.
Nagoradhana scheme is part of the grant,
A part of the, pardon me, your lordship.
parcel of that grant only.
Grant, yes. Your lordship, I've brought the order sheet of the earlier writ petition, your lordship, wherein it is stated that certain amount is already released. May I be permitted to produce it, your lordship?
My lord, may I make one submission? My lord,
Not me. We are not calling upon.
very well.
We call upon ourselves.
My lord, only the prayer in the, my lord, the prayer in the representations may be seen, my lord. It is not for release. It is for seeking approval. My lord may take page 1031 in volume 3.
Prayer.
Yes, in the representation, they want us to consider the representation. My lord may see the prayer in the representation, what they have sought for.
May I produce the order sheet of the previous writ petition, your lordship? In this, the interim order has been passed with respect to Dasarahalli constituency. 110.75 crores has been released, your lordship. Representation.
Lord, and the prayer in page 1036. They are seeking for approval for the proposals. It is only after the proposals are approved, my lord, can the, I'm sorry, my lord, I made.
Writ petition number 16-180 of 2024. Sorry, madam. Heard learned advocate.
Your lordship, may I be permitted to produce the order sheets of the connected writ petition?
Geeta R. Nair. Present is a public interest. Constitution. But they are advanced in the petition. The issuance of State of Amendment.
And you are saying.
The sum of is 78 crores. In respect of the tender public works. Tarsahalli. Which are stated to be pending. The petitioner infrastructural project. Pension. Grant them. Take the put for is that on 1 to 19. This must take state credit. Pensioning grant of rupees 570 crores for the purpose of development of the Darsahalli Assembly constituency. Stated that the state assembly constituency is carved out of 110 villages. And the area is covered under the Chief Minister's new Bangalore planning scheme. It stated that cabinet not C capital. It is 17.9. The proposal for the proposal was mooted for modifying the aforementioned notification 1 to 19 in relation to the grant amount. Given to the said cabinet note dated 17/9/20. Grant allotted to the Tarsahalli constituency was cancelled. Stated that thereupon the five which was not same for premature new represented the pending representation of the petition public entity represented the petition pending because state of Yes, that it be that. Even for the petitioner is there. That's all in constituency. Required several infrastructural works to be undertaken. And that roads and other buildings are in dilapidated conditions. For repair and maintenance, the amount of grant could be expended. However, the grant was modified, cancelled and reduced, cancelled, modified and reduced to the detriment of the constituents and the interest of the public, interest of the people of the constituents. Payment of the constituents, the payment of the interest and people of the constituents. $10.75 crores. State grant were approved for tendered works under the chief minister's supposed to be Nagoratna NFURATHA scheme. Number 2861 was directed for release of the amount. However, that's going to be for the approved tender works and balance of 78 crores is yet to be released. It is case that works to the tune of the 90 crores are still pending. Approval before fund number 2. That's the municipal secretary of urban development part. It was on the base of the above premise and context that is there as are made seeking amendments for release of the amount towards the grant. The kind paragraph, the kind and nature of grievance sought to be raised is the subject matter not fit to be brought by way of public interest litigation before the court. Sanctioning of grant, the extent thereof, the cancellation, modification, reduction or enhancement of such grant to be given to the constituent assemblies and for the betterment of the people of the assembly is the subject matter to lie entirely in the domain of elected government. As to what grant is to be sanctioned for a particular assembly, constituency, or part of the area of the state is the decision entirely to be taken by the executive. Full stop. It is essentially a policy decision of the popular government. Correct. The High Court, in exercise of powers and jurisdiction in Article 226 of the Constitution, would not make inroads in the decision-making process in such areas. Full stop. A writ of mandamus does not lie to direct the elected government to sanction or release or increase or decrease the amount of grant which may be decided by the governmental authority in their wisdom. The process of decision-making process,
May I interrupt?
no, is guided by host of the considerations, from many of which are such which are not governed by, which cannot be subjected to any judicially manageable criteria. The popular government is the best judge for taking care of the needs and interests of the assembly constituencies and the peoples, constituency people, citizens and netizens. Invoking public interest jurisdiction of the court in such matters and in such spheres cannot be said to be well conceived. Paragraph. The petitioner herein is an elected representative. Full stop. He is a member of Legislative Assembly. Full stop. It is always open for the petitioner to flag such issues before the House or before the government and its competent authorities. Full stop. Filing of writ petition in the nature of public interest and seeking relief on such scores could not be said to be justified, nor such public interest litigation can be entertained. The policy decision, policy decision, these are the decisions essentially to be taken by the cabinet, essentially to be taken and approved by the cabinet. For all the aforesaid reasons, the present public interest litigation is thoroughly misconceived and could not be entertained. It is dismissed. Submit that the representation dated 8/5/24 made by the petition to the Secretary of the Chief Secretary of the Government of Karnataka. Makes prayer to give the approval of the proposal with grant. It was highlighted that it is entirely the function of the government and that court may not. And the prayer before the court in this regard is not well found. Come with the better BIL.
Obligement.
7 and 8 are urgent. Still number 9. Rajaram P.
Lord, I appeal for the appellant's counsel in this matter. I appeal for the appellant's counsel. There is a delay in filing the writ appeal for which, seal number 9.
You have 3,000 days notice written.
May I persuade my lords, with reference to the Anantnag judgment of the Supreme Court, we fall within the 6 principles laid down by the.
Anybody is appearing the other side?
No, it's it.
Written
I didn't hear it properly.
19th August.
I'm obliged.
Yes. So number 10. Mr. Pradyumna Narasimha.
Also delay is there.
I appeal for the appellant, my lords. There's a delay, my lords, of 86 days.
Same order.
90. Read.
Still number 11.
Next to appear on behalf of my lord appellant.
T. Vignesh.
Respondents.
Proceed, my lord. My lord, it's a matter, my lord, I agreed by the, my lord, order dated, my lord, 12th January 2024, at annexure, my lord, page number 23. My lord, passed by my lord, learned signal judge. What had happened, my lord, in this matter, my lord, the appellant is a secured creditor. My lord, for recovery of, my lord, his dues from the borrower, we put the property for, my lord, auction under Securitization Act. On, my lord, 22/10/2021. My lord, the respondent, my lord, participated in the auction. My lord, in fact, the valuation which we, my lord, intimated, my lord, is 11 crore on, my lord, 22/10/2021. I'll just point out, my lord, I'll come to the document. My lord, the respondent is, my lord, participated in the auction. My lord, there are 3 bidders. My lord, from 11 crore to, my lord, it went up to 13 crore. And, my lord, the respondent considered as the, my lord, highest bidder, and we issued a sale confirmation. That is at, my lord, page number 123. 123, my lord. I'll just read the, my lord, letter dated 30th/11/2021. If my lord permits. In terms of the above acceptance letter dated 29/11/2020, you have remitted 25% of the bid amount, and we are glad to inform that the sale is confirmed in your favor by the bank, and you are advised to remit balance of the amount of rupees 13 crore on or before 14 December 2021, failing which the 25% of the amount remitted by you shall be forfeited forthwith without any further notice to you. My lord, I'll just draw my lord's kind attention, my lord, rule 9(3) for a moment of the security interest rules. In fact, my lord, I have given 2 opportunity, that also I'll just point out, then I'll come to section 9, rule 9(3). My lord, later at page number 124, the respondent approached the appellant and sought some time. And my lord, the appellant considered at page number 126 on 21/12/2021, wherein, my lord, I'll just read your request of extension of time for payment of the balance sale consideration of rupees 9 crore 75 lakh is considered favorably, and you are permitted to time till 28/12/2021 for payment of the said amount. It may noted that failing to deposit the said amount within the extended time frame by you in pursuance to said auction, the amount already deposited will be forfeited without any further notice. My lord, later, my lord, at page number 127, my lord, the respondent again given a representation to the bank for extension of some more time. Where, my lord, we have given, my lord, again, my lord, time, my lord, as per rule 9(4), which is, my lord, time permits me to, my lord, grant up to 90 days. I'll just, my lord, we have page number 129, we again considered and we are granted an opportunity.
Time permit is 90 days.
9(4), my lord, I'll just point out.
90 days.
90 days.
You had thrice asked for time.
Please, my lord.
3 times you
We are granted. All 90 days we are granted. all 90 days which is entitled, my lord, which you are granted in this matter.
No, you asked for extends for at least 2 times, 3 times,
3 times.
3 times.
It's a fact. It's a, which you are granted, my lord, which permits 9-4.
So it covers, it completes 90 days?
Yes.
Then,
Yes, my lord.
That it does.
so 3 extension will constitute 90 days.
Ultimately, my lord, though they didn't extend it. by
At
the-
a time, not 90 days.
Not
but
at a time.
Total 90 days.
90 days.
Ultimately, when their forfeiture notice came, my lords, in March 2022, it's a fact that 90 days had elapsed by then.
So he could get total 90 days
Yes, my lords.
by
Though,
by virtue of 3 extensions.
Please, my lord.
yes. Though, my lords, here the point on which the learned single judge has gone is that the bank has entered into a one-time settlement with the original borrower for 41 crores.
I just
Which
pointed
they
to that.
withheld from us and also from the honorable court. When we made an application before this honorable court, those details very reluctantly came out.
No, my lord. It's not
And
so.
in light of the one-time settlement, the finding was that there is no question of loss because the underlying debt itself is eroded once there is a one-time settlement. The question of them then, my lords,
Your bank.
I'm the bidder, my lords. My friend is for the bank.
I am for the bank.
You are for the-
I am for the banks. My lord, later, it's not in dispute, my lord. We have given 90 days of time, my lord. I'll just point out, my lord, rule 9-4, what it says, my lord. 9-3 and 9-4. Rule 9-3. On every sale of immovable property, the purchaser shall immediately, on the same day or not later than next working day, as the case may be, pay a deposit of 25% of the amount of the sale price, which is inclusive of earnest money deposited, if any, to the authorized officer. In this, my lord, 9-3 is complied by my lord respondent. 9-4. The balance amount of the purchase price payable shall be paid by the purchaser to the authorized officer on or before 15th day as confirmation of the sale immovable property or such extended period may be agreed between the borrower, purchaser and the secured creditor, in any case not exceeding 3 months. Rule 9-5, my lord. In default of payment within a period of mentioned in sub-rule 4, the deposit shall be forfeited and the property shall be resold and the defaulting purchaser shall forfeit all claim to the property or to any part of sum for which it may be subsequently sold. It is the case, my lord, wherein it is not in dispute, my lord. I am not given 90 days time. I have given. Where, my lord, rule 9-4 provides, my lord, I have given all 90 days. My lord, which they are not utilized, left with no other option, my lord. I, my lord, on, my lord, page number 135, letter dated 2/3/2022, I said, my lord, I forfeited their money. And, my lord, I issued a fresh sale notice. In the meantime, my lord, the petition on fresh sale notice issued on, my lord, 21/3/2022. My lord, what had happened in the subsequent sale when I issued? My lord, again, my lord, I issued the auction notice at the reserve price of, my lord, 11 crore rupees. My lord, no bidders came because of, except, my lord, one bidder. We sold the property for 11.02 crore. My lord, initially, my lord, when I conducted the auction, my lord, there are 3 bidders. Highest bid was, my lord, 13 crore. The second highest bid, my lord, 12 crore 99 lakh. And, my lord, for the default made by the, my lord, respondent, my lord, I conducted auction once again. And that time, my lord, I recovered only, I am able to sell the property for 11.02 crore. I suffered, my lord, 1.98 crore loss there. My lord, here, my lord, subsequent to that, my lord, the petition, my lord, the respondent approached the learned single judge. In fact, we pointed out, my lord, the first, my lord, we had taken 2 contention, my lord. One, my lord, that application ought to have been filed, the petition, the auction purchaser ought to have been gone before the, my lord, DRT because of the, my lord, the judgment of the Honorable Supreme Court, which I relied. And one more submission which I taken, my lord, before this learned single judge, wherein, my lord, 9-4 is a mandatory in nature, wherein we have given 90 days time. And, my lord, he is not paid the entire money. That is the reason left, my lord, as per rule 9-5, my lord, I forfeited and, my lord, I issued a fresh sale notice. My lord, I would like to draw, my lord, the 2 judgments which I already filed the compilation of judgment along. One is, my lord, Agarwal Tracom. I filed along the compilation of judgment. I'll my lord, the second judgment, page number 30, Agarwal Tracom, it says that, my lord, I'll draw my lord's attention at page number 39, para 28 and 29. Para 27 also little relevant, my lord. The reason is that section 72 imposes the tribunal to examine all the issues arising out of the measures taken under section 13(4), including the measures taken by the secured creditor under rule 8 and 9, for disposal of the secured asset of the borrower. The expression provisions of this act and the rules made thereunder occurring in subsection 2, 3, 4 and 7 of the section 17 clearly suggest that it includes the action taken under section 13(4) as also includes therein the action rules 8 and 9 which deal with the completion of the sale of the secured asset. In other words, the measures taken under section 13(4) would not be completed unless the entire procedure laid down in rules 8 and 9 for the sale of the secured asset is fully complied with by the secured creditor. It is for the reason that tribunal has been empowered by section 17, 2, 3 and 4 to examine all the steps taken by the secured creditor with a view to find out as to whether the sale secured asset was made in conformity with the requirements contained in section 13(4) read with the rules or not. Para 28. We also notice that rule 9(5) confers express power on the secured creditor to forfeit the deposit made by the auction purchaser in case the auction purchaser commits any default in paying installment of sale money to the secured creditor. Such actions taken by the secured creditor is, in our opinion, a part of measures specified in subsection 13(4), and therefore it is regarded as measure taken under section 13(4). Read with 9(5). In our view, that measures taken the secured creditor 13(4) commence with any of the action taken in the clause A to D and end with the measures specified in rule 9. In our view, therefore, expression any of the measures referred to in section 13(4) taken by the secured creditor or the authorized officer in section 17 would include the actions taken by the secured creditor under the rules which relate to the measures specified in section 13(4). My lord, I took a specific contention before the learned single judge. They would have filed the, my lord, petition under section 17 before the DRT. My lord, the second judgment which I am relying, my lord, at page number 42, the recent judgment in the case of, my lord, the authorized officer Central Bank of India versus Shenmuga Velu, that, my lord, starts from, my lord, page number 42. I would like to draw my lord's attention at, my lord, page number 85. Forfeiture under surface rules. My lord, all the judgments, my lord, which they relied. And my lord, para 59, we come to the aspect of applicability of section 73 and 80 of 1872 Act. The Surface Act, more particularly rule 9(5) of the surface rules, in so and so, this court made a pertinent observation that section 35 and 37 retrospectively of the Surface Act and unique scheme of the overriding provisions. However, the scope of the ambit of section 37 is restricted only to the securities law in relevant portion so and so produced. And my lord, I'll just skip, my lord, para 60 and 62 onwards, my lord. 61 also, my lord. The legislature through rule 9(5) of the surface rules has made a conscious departure from the general law by statutory providing for the forfeiture of earnest money deposit of the successful auction purchaser for its failure in depositing the balance consideration within the statutory period. No doubt the forfeiture is a result of breach of obligation, but the consequence of forfeiture is in such cases is taking place not because of the breach, but because of operation of the statutory provisions providing for the forfeiture that is attracted as a result of breach. If the consequence of the forfeiture is purely a matter of breach of contract, then there would have been no occasion for the legislature to specifically provide for the forfeiture through statutory provisions, and it would have simplified relegated to consequences of such breach to already existing general law under section 73 and 74 of 1872 Act. However, the legislature has consciously provided for only one consequences in the event of failure of the successful auction purchaser in depositing the balance amount, that is forfeiture, and has not provided the imposition or any other stipulation by the secured creditor. In the event of a breach, this has been done keeping in mind the larger object of the Surface Act, which
When
is
did you conduct the second auction?
My lord, I conducted second auction on 21/3/2022.
Not furnished, but that's the finding of the learned single
Not
judge.
conduct.
That no material placed on record to show that the second sale took
And
place.
and the settlement was there.
Settlement was
Subsequent
entered
to
into,
that.
one-time settlement.
No, I'll just point out, my lord, what would happen, my lord, after giving a 90 days
What is wrong in refunding?
refund, my lord, which I can't, my lord, rule 9(3) and 9(4) says, my lord, they purchase a property under, my lord, as is varies, as is what is. My lord, dare not, my lord, kindly see the, my lord, loss incurred by the secured creditor here. My lord, if they would have not participated, my lord, the second bid was, my lord, 12 crore 99 lakh. I would have recorded, my lord, 2 crore 99 lakh extra. Because of him, he given a, my lord, highest bid of 13 crore, wherein he has not completed the sale transaction. Therefore, my lord, I gone, my lord, second sale, wherein, my lord, I am able to get, my lord, only 11 crore. That is a loss which I incurred because of the, my lord, the respondent. My lord, in respect of, my lord, settlement, my lord, what had happened, my lord, subsequently, my lord, I resold the property. I am able to get, my lord, 11.20.
You are a guarantor.
I am, my lords, the bidder. I made the deposit of 3.25 crores. Your lordship's question is answered at para 9 of the order of the learned single judge.
But then where is the question of rule and etc.? Rule 9.
My lord, here.
My lords, if my learned friend does not mind, para 9 and 10, my lords, make the entire picture clear at page 38.
Yes.
If I may read, my lords, for your lordship, certain developments take place during the pendency of the writ petition.
Yes.
The petitioner, that is me, my lords, however, is kept in the dark. The petitioner, on coming to know that another sale has taken place of the very property in respect of which the petitioner had emerged as successful bidder, files an application under the RTI Act seeking those details. The stand of the bank was that in the second sale, the bank had suffered loss, as the property had to be sold for a lesser price than what was the amount of bid when the petitioner had participated in the auction. The same was not divulged, holding that the petitioner was a third party. It is then that the petitioner files an application before this court on 3/11/23, appending certain documents, including the encumbrance certificate, qua the subject property. The encumbrance certificate does not show, lordships may mark this, does not show any name of an auction purchaser or transfer of property to the name of the auction purchaser. Therefore, if the bank had put up the property for sale for the second time and has registered a sale certificate in favor of the second auction purchaser, it ought to have been reflected in the encumbrance certificate in the least. The bank has filed its statement of objections, but nowhere mentions the notification of second sale or name of the successful bidder in the second sale. Therefore, the second sale having taken place at the hands of the bank itself is in doubt. Now, my lords, the OTS dimension, para 10. Yet another circumstance that would belie the stand of the bank is that the bank generates stocks of OTS.
Now, if the second auction was conducted, what is the relevance of it?
My lords, the relevance, they pleaded that second sale to say ostensibly they had suffered some loss there. But that material was never placed.
They pleaded about second auction.
Yes, they pleaded.
To contend that they suffered a loss.
Some loss. That material was never placed. But the overwhelming development, keeping that aside for a moment, is the fact that in the interregnum, they have made, my lords, a one-time settlement with the borrower, which is para 10. Yet another circumstance that would belie the stand of the bank is that the bank generates stocks of OTS with the borrower and settles the entire loan that was in due for an amount of rupees 41.24 crores. And it is stated that the entire loan amount is recovered. This is not made known to the petitioner. In reply to the application so filed, the bank admits the said payment and settlement. The relevant paragraphs of the objections read as follows. If my lords please come over the page to para D. With reference to para 5 of the application, save and accept what are matter of record, every allegation contrary thereto, inconsistent therewith are denied. The respondent bank has produced all the documents which are necessary for the present case. However, the documents pertaining to OTS cannot be claimed by the petitioner, as the petitioner is a third party to the transactions entered between the bank and the borrower. Sheer lies and wrong notion, etc., my lords, they allege against me for some reason. Now, my lords, please come to page 41, the continuing reasoning.
In your original petition, your petition.
I am the petitioner.
Original petition, the prayer was only to extend the time.
To refund the amount. If your lordship just see my prayer in the writ,
Refund is there?
page 65.
Refund prayer is there?
Yes, my lords. Page 65. If your lordships please see at page 72.
Yes. Refund the
Refund. And the learned single judge follows, my lords, a judgment of this honorable court, a judgment, my lords, of the Calcutta High Court and, my lords, the Andhra Pradesh High Court, all of which have consistently taken the view that once there is a one-time settlement, the debt itself, my lords, does not subsist. Therefore, the question of forfeiture would not arise.
Lord, my answer would be this. My lord, it is not in, non-compliance of, my lord, rule 9.4 and, my lord, compliance with 9.5, my lord, it is not in dispute. My lord, in fact, my lord, he's not complied 9.4, my lord, left with no other option, my lord, I invoked 9.5. Subsequent to that, my lord, I issued a, my lord, sale notice, which I sold a property.
What is rule 9.5 letters?
Please, my lord. Rule 9.5 says, my lord, in the default of payment within period mentioned in sub rule 4, the deposit shall be forfeited. to the secured creditor, and property shall be resold, and the defaulting purchaser shall forfeit all claims to the property or any part of the sum of which it may be subsequent sold. That has been, my lord, confirmed in the recent Supreme Court judgment in Shenmugavailu. My lord, after, my lord, 9-5, I issued a sale notice. My lord, I sold a property. I have no other security. My lord, I entered a settlement with the, my lord, borrower. That nothing to do with, my lord, petitioner, respondent case here. Petition, my lord, the respondent has to answer whether they're complied 9-4 or not. If not complied, my lord, whether I am justified in respect of, my lord, forfeiture of under Rule 9-5.
Where is Rule 9? Let us.
Rule 9-4. 9-4. I'll just read 9-4, 9-5 both, my lord. 9-4. 9-3 is complied here. 9-4. The balance amount of the purchase price payable shall be paid by the purchaser to the authorized officer on or before the 15th day of confirmation of the sale of the immovable property, or such extended period as may be agreed upon in writing between the purchaser and secured creditor, in any case not exceeding 3 months, which I pointed out before this one, because we have given 90 days time, which is permissible under Rule 9-4. 9-5 says, in default of payment within period mentioned in the sub-rule 4, maximum at 90 days, the deposit shall be forfeited to the secured creditor, and the property shall be resold, and the defaulting purchaser shall forfeit all claims to the property or to any part of the sum for which may be subsequently sold. Which, my lord, I did it. My senior counsel, my lord, argument before this honorable court. Subsequent to this, I sold a property. Yes, I am entitled to sell it. I sold a property for 11.02 crore, which I filed an affidavit before this honorable court. Yes, my lord, that property that time it was not registered. The reason is this, my lord, that some duty, my lord, they're payable to government. That is the reason sub-registrar is refused to, my lord, register the property. Later, they filed one more writ petition, where the writ petition, my lord, given directions to, my lord, sub-registrar to register the property, which is recently. A writ petition number also I'll furnish. That is the reason, my lord, it is not shown in the income certificate. In respect of, my lord, one-time settlement offer, if there is no security available, why would there only one security here, my lord, which I sold, and I record, my lord, 11.02 crore. I, my lord, settled with the, my lord, borrower. How, my lord, relevant to this, my lord, respondent case here in, my lord, I fail to understand. My lord, dare not complied the 9-4. Left with no other option, my lord, 9-5, my lord, I invoke. That has been confirmed, my lord, in the Shenmugavailu case in the Honorable Supreme Court, my lord, which I just pointed out. Wherein, my lord, 9-4 and 9-5 is mandatory in nature. The judgment which I relayed, my lord, in the case of, my lord.
So what was the total due?
Total due. My lord, it was including, my lord, penal interest and other things, it's approximately 200 crore. And, my lord, we have settled for 14 crore. 42 crore, my lord, with there is no property. That is the reason we got it settled.
You settled.
We settled subsequent to, my lord, sale of the property. My lord, we put the property for auction. Auction, my lord, yeah, 5323. The sale rate is 21,322. 21,322.
Any Supreme Court decision which says that the mandatory nature of Rule 9(5) will vanish or will not, will not, will lose its rigors once it is in a settlement?
Or no, my lords. There are three High Court views on this point.
Court views.
Yes, there is no Supreme
Our
Court.
High
judgment.
Court.
Our High Court, my lords, a learned single judge, which is referred in the judgment, and a judgment of the Calcutta and the Andhra Pradesh High Court. They are all referred, my lords, in the impugned order. Supreme Court on this point, there is none.
In the bunch of the judgment relied on by the council, there is judgment of Supreme Court.
That is not a case of OTS, my lords. That is a simpliciter case, my lords, of a breach.
Authored by Justice Pardiwal.
Please, my lords. That is only on 9(4) and 9(5). That is not a case where there was any instance, my lords, of a one-time settlement.
But how one-time settlement could take away the statutory force of Rule 9?
My lords, because the very underlying debt, my lords, which is sought to be enforced, itself stands eroded. And that is the view taken by the Honorable High Courts. My learned friend is harping on the rule. The rule is not the substantive provision. The provision is section 13.
Let us.
Yes, my lords. These rules that my learned friend read to your lordships are framed, my lords, in exercise of powers conferred by subsection 1 of 38, read with subsections 4, 10, and 12 of section 13. Now, 13, my lords, is a provision for enforcement of security interest. Notwithstanding anything contained in section 69 or 69A of the Transfer of Property Act, any security interest created in favor of any secured creditor may be enforced without the intervention of the court or tribunal by such creditor in accordance with the provisions of this act. Then 2, where any borrower. So first, my lords, a borrower must subsist. A one-time settlement, my lords, does away with the very notion of a borrower who is under a liability to a secured creditor under a security arrangement, makes any default in repayment of secured debt or any installment thereof, and his account in respect of such debt, lordships may kindly mark this word debt, is classified by the secured creditor as a non-performing asset, then the secured creditor may require the borrower in notice to discharge. And thereafter, my lords, the steps are taken, one of which is auction. Now, these words, my lords, borrower and debt, assume importance. Because debt, my lords, is defined to mean a liability. If the liability, my lords, the one-time settlement, it goes without saying, once the OTS is entered into, the liability is discharged. Therefore, the borrower ceases to be a borrower. And the word debt, my lords, is defined in section 2HA. That definition, my lords, reads that debt shall have the meaning assigned to it in clause G of section 2 of the DRT Act, which I will take your lordships to, and includes unpaid portion of the purchase price of a tangible asset, any right, title, or interest on any intangible asset, etc., which secures the obligation to pay the unpaid portion of the purchase price of such asset. Now, my lords, since it refers to the Recovery of Debts Act, if your lordships please see 2G of the Recovery of Debts and Bankruptcy Act 1993, which defines, my lords, debt to mean any liability which is claimed as due from a person.
Debt in this act,
Yes, my lords, debt your lordship saw 2HA. My lords, it applies the definition of debt in 2G of the Recovery of Debts Act. And if your lordships kindly come to 2G.
So 2G plus includes.
I'm sorry.
2G plus what is?
Yes, my lords, please. Plus what is here. And 2G is crystal clear, my lords.
Now, give it.
My lords, debt means any liability inclusive of interest which is claimed as due And if my lords see the reasoning over the page at 54, this court has to therefore decide it, since the bank does not have any further claim and has voluntarily given up its claim against the original borrower by its one-time settlement proposal, which is an accord and satisfaction, the bank cannot lay any claim on the amount of rupees 15 lakhs lying in the bank's custody. This is to be refunded to the writ petitioner.
Where you are reading?
I'm so sorry, my lords. I'm reading at ink page 54, my lords.
54.
Yes, my lords. This is an extract from the judgment of the Andhra Pradesh High Court. Beginning with the words, this court has to therefore decide. Lordships have it. Grateful.
This court has to therefore.
Yes, yes, my lord. This is an extract from the AP High Court. Since the bank does not have any arguments, Mr. So-and-so has placed reliance, my lords. There Alisha is referred, and ultimately the order, my lords, was quashed in light of the OTS that your lordships get at page 56, internal para 16. And a direction given thereafter, my lords, to refund the forfeited amount of 1 crore 70 lakhs. And it is these judgments, my lords, which are followed by the learned single judge to hold, my lords, the bid reserve price was 11 crores. They have recovered 41.24 crores. So the question of pleading any loss or my lords, hardship does not arise. If anything, it is really an unjust enrichment.
Recovered 42 crores.
42 crores. That's an admitted fact. If I may give your lordships the exact amount, it is 41.24 crores, which is referred at the order of the learned single judge at para 10, my lords, 41.24 crores. And all of this material, my lords, please see the conduct of the bank suppressed. When we make a right to information application, they withhold it from us. Before the learned single judge, upon an application made alone, my lords, very reluctantly does this material come before the honorable court.
Very well. Anything further?
Lord, 3 dates are, my lord, or relevant, my lord, in this matter. My lord, I invoked 9.5 forfeiture on, my lord, 2/3/2022. Pursuant to, my lord, 9.4. My lord, I resold the property, my lord, on 19/3/2022. My lord, I given a one-time settlement in favor of, my lord, the borrower, which is my debt is huge. My lord, on 5/3/23. In all the cases, my senior counsel relied, my lord, where, my lord, OTS offer and, my lord, the sale, my lord, at together. It is a case, it is not so, my lord, where, my lord, I invoked, my lord, 9.4, 9.5. I forfeited the money, then I resold it. Then for the remaining money, my lord, I entered an OTS offer with the borrower. My lord, before the learned single judge, my lord, I have, my lord, taken 2 contention.
The auction was held when?
My lord, the second auction taken place on, my lord, 19/3/2022.
No. Auction where the petitioner was a bidder.
29/11/2021, my lord.
29th August.
29/11.
29/11.
11/2021.
And
forfeiture taken place on, my lord, 2/3/2022.
OTS took place on?
OTS took place on, my lord, 5/3/2023.
5?
3/2023. My lord, my forfeiture, my lord, much before. My lord, my forfeiture which, my lord, taken place, my lord, on 2/3/2022, much before, my lord, I entered a OTS. When, my lord, invoked 9(5), that time, my lord, that is in existence. That's what, my lord, Honorable FX Court says in the case of Shinmuga Velu. My lord, when I put the property for, my lord, as is where is, as is what is basis, my lord, now, my lord, at the max, my lord, I can give 90 days, not more than 1 day.
For your own reasons, you accepted that is what Karnataka API Court has used.
Supreme Court, my lord.
We are not on.
My lord, one-time settlement is offer, my lord. I'll just put it in, my lord. My lord, one-time settlement is, my lord, how it take place, my lord. When, my lord, I don't have any security. When, my lord, I'm not in a position to, my lord, recover any money from the borrower.
Very well. Any judgment you want to rely on?
My lord, that's, my lord, the Shinmuga Velu judgment. It says that, my lord, 9(4) and 9(5) is a mandatory.
Which one?
That the last judgment which I, my lord, I'll just.
Justice Pardiwala.
Justice
Pardiwala judgment.
That is what I was reading.
It is, my lord, from para 91.
Para, yes. Para
9, my lord, I'll start it from, my lord, page number 85, my lord,
Yes,
forfeiture
85.
under the surface rules.
correct.
Para 59, 60,
60, 61, 62.
62, 63, 64.
63, your lordships may kindly mark. 63, my lords. However, the legislature has consciously provided for only one consequence in the event of failure of the successful auction purchaser in depositing the balance amount, that is forfeiture, and has not provided for imposition of any other stipulation by the secured creditor in the event of breach. This has been done keeping in mind the larger object of SURFACE Act, which is to facilitate recovery of a debt. Just wanted to emphasize that part.
Then, my lord, para 79. 79 to, my lord, 79, I'll just read, my lord. Since 9 sub-rule 5 provides for the forfeiture of only earnest money deposit of the successful auction purchaser, that is only 25% of the total amount. By no stretch of imagination, it can be regarded as panel clause by virtue of the aforesaid stated decision of this court in so-and-so case, and is such section 73 and 74 of 1872 Act will have no application. And then, my lord, 81, 82, 83, then I'll skip, my lord, 84 to, my lord, 90. From 91 to, my lord, full judgment, wherein Honorable Supreme Court, my lord, relied all the judgments and, my lord, pass in order, it is mandatory in nature.
That is all.
My lord,
We'll consider.
I took one more contention before the learned single judgment. In fact, my statement of objection also. I said, my lord, they would ought to have gone before DRT under section 17 because of, my lord, the judgment which, my lord, which I quoted, my lord, the second judgment, Agarwal Tracom. The Honorable FX Court said it is pursuant to, my lord, 13(4). Section 17 says any aggrieved measures taken under the secured creditor has to go under section. I'll just read the section 17(1) for a moment, my lord.
We'll continue after recess.
I'll just point out 2 minutes, my lord. 17(1) says, my lord. 17(1). Please. Any person, including the borrower, it means, my lord, including auction purchaser.
Reading what?
My lord, section 17(1) of SURFACE Act.
17 of SURFACE.
17(1). Aggrieved by any of the measures referred to in subsection 4 of section 13, taken by the secured creditor or his authorized officer under this chapter, may make an application along with the such fee may be prescribed to the debt recovery tribunal having jurisdiction in the matter within 45 days from the day on which the measure been taken. Wherein, my lord, in the Agarwal Tracom, my lord, in the para 27 and 28, the Honorable Supreme Court confirmed the same. Even auction purchase, the word, my lord, they employed, my lord, even auction purchase has to go to DRT. That is my first contention. My lord, they would have gone to before DRT, not before the writ petition. My lord, in the Agarwal Tracom judgment in para 27 and 28. In the subsequent judgment, it says that, my lord, 9495 is mandatory. That's all.
I'll just place Alisha's judgment since your lordships are considering. I'll just leave it with your lordships.
So you are relying on all these judgments, Mr. Counsel, which are the part of this compilation. In particular, for Justice Pardiwala says.
Please, my lord. Justice Pardiwala, my lord, the second judgment starts from, my lord, page number 30, Agarwal Tracom. Okay. Para 27 and 28 is relevant, my lord.
All.
And the other two judgments, my lord, says that, my lord, alternate remedy under section 17. Matthew Casey and transfer.
Yeah.
May I just place Alisha's judgment? And Alisha is referred to in his lordship's Justice Pardiwala's judgment.
If you can pass over all the three judgments.
I'll leave a copy.
Physical copy.
I'll leave it with my lord.
The hard learned advocate, Mr.
Vignesh
Shetty Vinesh Shivaram for the appellant. And learned senior advocate from Aditya Sondi, assisted by learned advocate from so and so, to the respondent, at length. Learned advocates for the respective parties stated that they argued the appeal finally. They further stated that the pleadings are over and no further are required to be added or supplemented. Resort for judgment.
Grateful.
In the course of the day, I will leave copies of it.
Grateful.
So obliged to your lordship.
Lords, serial 68, 14%. Today it is.
So we are coming after this.
Thank you.
permission. Serial number 13, I space for time loss. Serial number 13. And 13.
You are for appellant.
Petitioner.
So when do you want?
Next week, start date, my lord. Next week, my lord.
2nd August.
And also 71, my lord. And also 71. Two days, my lord.
12th August.
Serial number 19, please, my lord. Week accommodation may be granted, please. Serial number 19, please, my lord.
19.
Yes, please, my lord. Request, we required to file return synopsis, my lord. The week accommodation may be granted, please, my lord.
That is that PIA.
Please.
19th of August.
Much.
Serial number 16,
16 years.
appearing for complaint in this matter, my lord.
Complied, my lord.
Complaint.
Complied with
Yes.
learned advocate for the parties jointly stated that the order under contempt is complied with. In that view, the present contempt proceeding does not survive. They are accordingly disposed of as not surviving. 15, 15, 15.
16, my lord.
16.
Sorry, 230 matters. Serial number 88. Withdrawal.
No. Repeat after 4 weeks. 6 weeks.
6. This is number 89. So withdrawal of writ petition. Ganpati Bhatt.
Petitioner. So going through the memo of withdrawal. None is present. Full stop. Adjourn.
This is number 89. Petitioner.
Adjourn to a suitable date. Adjourn to a suitable date. So we are withdrawing.
Withdrawing.
Figures on record. Memo for withdrawal dated 10/7/24. Thereby the permission is sought to withdraw the writ petition. As not pressed, the writ petition is disposed of as not pressed any of the memo and the request made by learned counsel, Mr.
Ganesh Gowda. Ganesh Gowda.
So and so is personally present in the court. Petition is accordingly disposed. Both same separate.
Yes, number 90. So Badrinath.
Prefer complaint.
Appearing for case number 1.
What 89 and 89.1. Yes.
Page number 14, order of the learned single judgment. Operative position, page number 17. Para 4. In view of the aforesaid submissions, the respondent 2 to 6 are directed to consider the asphalting the link road running from 24th Main Road to Kothnur Main Road in the BBMP Ward number 194 in accordance with law and pass appropriate orders within a period of 3 months from the date of receipt of certified copy of this order. Accordingly, the petition is disposed of. In their count, in their up to date, they have respondents have filed an up to date. In up to date, as per the photo itself, it's only half road is formed. The full road is not completed. Page number 6.
My lords, page number 4 of my affidavit, my lords, and para 3 of my affidavit contains the entire road measures of 280 meters, my lords. Since there is a public road, my lords, we have undertaken the asphalting. Since there is a dispute in that some area of that, my lords, of 150 meters to 100 meters, where we couldn't asphalt it, my lords, that I have stated in my affidavit. When the
Regarding the dispute, it is not, it's a road itself, clearly the photo itself has been seen.
The page 4 and 5, the photographs I have produced, my lords, where the BBMP has asphalted the road. Page 4, my lords, where we have started. Page 5, my lords, where it is the complainant's house, my lords, in front of his house, the road has been done, my lords. And further, page 6, my lords, where we have not done the road, my lords, there is a dispute.
Dispute of?
Dispute, but it's not a public road, my lords. It belongs to the private person. So we couldn't do it. In the endorsement, we have stated in the first paragraph, my lords, when we started our work, my lords, that page number 9, the translated copy, my lords, when the labor work and the JCP went for the asphalting work, my lords, there was a public started making this, my lords, where we couldn't do the road because there is a dispute. That is the reason the endorsement came to be issued to the complainant, my lords, as per the order of the learned single judge. In view of this, my lords, we have complied the order of the learned single judge.
It's only partly complied.
Para 3 of the order of the learned single judge, my lords, where the undertaking are given by the respondent who have appeared before the. If my lords, may I read it, my lords? Para 3 of the learned single judge. Page 16. There we have stated, my lords, if it is a public road, the respondent would undertake the asphalting the road. As per that, my lords, we have done. There is no willful disobedience as they have stated in their petition.
We are disposing.
Please.
Learned single judge by order dated 27th May 22. Directed as under from extracting from paragraph 4 of the order, recorded portion and page 70. The direction was therefore into inward comma to consider asphalting the link road running from 24th Main Road to Kotanuru Main Road in BBMP Ward number 194. Inward comma. In response to the notice issued by the court in the present contempt proceedings, respondent appeared and filed their compliance affidavit, which was affirmed by one Narendra Kumar, son of A. Rajab, A. Aparja. Narendra Kumar, son of R. Appa Chappa, APPA, JPPA, holding the post of Assistant Executive Engineer, Anjanapura Subdivision, Ward number 194. What did you write? Holding the post of Assistant Executive Engineer, Anjanapura Subdivision, Ward number 194. It is stated in paragraph 3 of the compliance affidavit that the link road running from 24th Main Road to Kotanur Main Road in BBMP Ward number 194 that measures 280 meters approximately. It was stated that the respondent BBMP has asphalted 180 meters out of 280 meters stretch. Full stop. The photographs were produced depicting the asphalting work carried on by the BBMP. Very good. It was stated that the BBMP considered the representation of the complainant and acted upon in compliance with the directions of licensing laws. The photographs appended with the compliance affidavit show that part of the road has been asphalted. The learned advocate for the complainant submitted that the entire road is not asphalted. Full stop. In response to this, learned advocate Ms. So and so for the respondent invited of the attention of the court to the governments in the compliance affidavit to state that part of the road is under dispute and the side portion is claimed to be of private ownership. It was submitted that since the dispute subsists about the ownership, the side road is not asphalted. Full stop. The paragraph. The road shows that the work of asphalting was being done and has been completed in respect of the relevant portion of the road to with the direction of learned single lines extending. Full stop. If the portion of the road is left out where the private ownership claim is where, which is claimed by private person, which is claimed for its ownership by a private owner, private person, comma. And if the said part is not asparted, it would not be said that the respondents have committed an contempt, much less willful contempt of the directions of learners in values. In any view, there is a substantial compliance. The doctrine of substantial compliance is applied. Most of the contempt proceedings paragraph are not required to be continued any further. They are closed and the petition is disposed of.
Number 91.
So only you, that is over, submissions are over.
I have to just conclude, but the other day I was reading to the provisions to drive the point whether the partners of a partnership firm can be equated to the personal guarantor, whether that is ultimately their point. But they have today agreed to the fact that partnership firm is not yet notified in terms of invoking section 95. Partnership firm jurisdiction will vest with only DRT, not the NCLT, is also now clear. Now, what will come to NCLT is only in cases of personal guarantors to a corporate debtor. Now, they say a partnership firm become liable to a debt. The partners of the firm would be treated as a guarantors. Therefore, they are trying to not drive an extreme situation saying partners are personal guarantors. Therefore, the partnership firm is also personal guarantor. Now, that is where I wanted to point out the provisions to drive the point that the code itself not creates a class as to the personal guarantors to corporate debtor while setting out the partnership firm separately. Now, Lordship will see section 2, because this notification came on 15/11/2019, saying that the personal guarantors to the corporate debtors will also be subjected to the provision of IBC. Now, just prior to that, this amendment comes, section 2 of the code. Section 2 application, the provisions of this code shall apply to A, B, C, D. Prior to this amendment in 2017, after D, with the words and, E was the only provision, which E read as partnership firm and individuals. Prior to the 2017 amendment, section 2 ended with E, subclause E. Subclause E said partnership firm and individuals. Now that was amended by bringing in E, F, G. Now E reads as personal guarantors to corporate debtors, a class by itself. Then partnership firm and proprietary firms. Then individuals other than persons referred to in clause E. So what was partnership firm and individuals at the inception of the code was amended in 2017, bringing 3 different classes of people. And one class among that is personal guarantors to corporate debtors. Now, this personal guarantors is again defined. Now, before that, in section 3 definitions, please see section 3, subsection 23. Defines person, includes an individual, an undivided family, company, trust, partnership, a limited liability, any other entity established under a statute. But if the legislature intended to bring this personal guarantors under any category, now 523 definition of personal guarantor, 522. Section 5, subsection 22. Definition of personal guarantor is given, means an individual. But if they had used a word, means a person. In terms of 523, a partnership firm would also have been a person there. They used an individual who is the surety in a contract of guarantee to the corporate debtor. So each of these words not has its own meaning. It initially said individual, then who is a surety? Surety is not defined under the code. But your lordship knows that Contract Act defines surety by a specific provision, section 126. Now under clause 337, what is not defined here, not it, definitions of Contract Act, Partnership Act will all apply, is also what my friend also referred. Then it says in a contract of guarantee to a corporate debtor. So each of these words are a qualifying words to make it applicable for a personal guarantor to corporate debtor in terms of the notification dated 15/11/2019. In absence of that notification, there is no scope for anybody to file any individual insolvency before the NCLT. In terms of part 3, it would have gone only before DRT. Only exception, this notification as a class which was created, personal guarantors to corporate debtor, was brought in. Therefore, not their contention that it has to be read into does not hold good. It is an absolute imagination which they are trying to extend for the mischief to play, saying that I have filed a petition, therefore there is a moratorium. Because in the arbitration proceedings, partnership firm is a party. There is no other individuals. So to bring this partnership firm within the scope of it and to claim a moratorium, they invent such a proceeding and take advantage of the provisions of the code. Because in terms of 95 and 96, what it said is that the mere filing, 96 will step in to provide a moratorium. So they wanted to make use of that. Therefore, Lord, all these ultimately boil down to the fact that whether there is any jurisdiction for NCLT to entertain this. But on your lordship being satisfied to these contentions, that there is a class by itself, it is only an individual who is a surety in a contract of guarantee, no other case it doesn't arrive. But it ultimately culminates into a point, therefore there is no jurisdiction for the NCLT. Once there is a lack of jurisdiction, there is no point in any contention saying that you should have allowed the NCLT to decide, or you should have said that RP, the resolution professional, has a scope to decide, or whatever they claimed as 44 days is the only period. But all those things does not hold good because absolute lack of jurisdiction is the ultimate issue. My friends refer to your lordship, not the Javerica judgment, pointing.
Moratorium which will start under section 96.
96.
Will last for 7 days.
That will last till the admission under section 100. That is where they are trying to satisfy a lordship. Not this admission from 95 to 100 is only a period of 44 days. But in fact, that is not so. I had pointed out to that very petition, after having been filed, nothing has happened. My getting a stay before the learned single judge itself was after about 30 days. Till such time, nothing had happened. So therefore, under the provisions of the code, 96 moratorium, which is called as an interim moratorium, will be there till the admission under section 100. Once admission happens, the further moratorium continues. The judgment reference, Javerica, was on the point of challenge to the provisions of 95 and so on, where your lordship had rightly pointed out, paragraph 83, they said, as one of the argument which was placed before the Honorable Supreme Court was that the partners of a partnership firm, which is referred as a partnership debt in 95-2, will be the driving factor for 95-1 also. But Honorable Supreme Court said that cannot bind 95-1. 95-1 deals a larger concept of individuals. Because under 2F also, not E, F, G, they said individuals other than what is referred in E. So one individual who is the personal guarantor to corporate debt. The other case would be partnership firms where there may be individuals as partners. Third case is that they said individuals who are not covered under E. So therefore, the Honorable Supreme Court said, 95(1) is standalone provision, 95(2) deals with only partnership firms. Now, what would be relevant for a lordship to consider this, my lord? The judgment of the Supreme Court in Lalit Kumar Jain. And I have circulated that copy in the last hearing. 2021 9 SEC 321. Where is it? That this case was a challenge to this notification dated 15/11/2019, and on the ground saying that you could not have a separate class as personal guarantors to corporate debtor because they will fall as part of individuals. Therefore, that classification which created and vesting with NCLT jurisdiction was wrong is the contention. Not only I'll point out to the relevant paragraph, not your lordship will come to page 385 of this judgment. Page 385, paragraph 95. I may read this paragraph 95. As discussed in the previous part of this judgment, insolvency proceedings relating to individuals is regulated by Part 3 of the Code. Before the amendment of 2018, all individuals, personal guarantors to corporate debtor, partners of the firms, partnership firm, and other partners, as well as individuals who are either partners or personal guarantors to corporate debtor, fell under one descriptive description under the unamended section 2E. So this entire class must fall under one description under 2E, which was partnership firm and individuals. The unamended section 60 contemplated that the adjudicating authority in respect of personal guarantors was to be NCLT. Yet, having regard to the fact that section 2 brought all these three categories of individual within one umbrella class as it were, it would have been difficult for the central government to selectively bring into force the provisions of Part 3 only in respect of personal guarantors. It was here that the central government heeded the reports of the expert bodies, which recommended that personal guarantors to corporate debtors facing insolvency process should also be involved in the proceedings by the same adjudicator, and for this necessary amendments were required. Therefore, made a conscious decision of making an amendment to creating a class separately, and this partnership firm partners were left separately. And this class, ultimately, the legislature wanted them also to be under the purview of NCLT only. Consequently, the 2018 amendment altered section 2E and subcategorized three categories of individuals, resulting in section 2E, F, and G. Given that earlier notification of 30/11/2016 had brought the code into force in relation to entities covered under 2A to 2D, the amended Act of 2018 provided the necessary statutory backing for the central government to apply the code in such a manner as to achieve the objective of the amendment, that is to ensure that adjudicating body dealing with insolvency of corporate debtor also had before it the insolvency proceedings of personal guarantors to such corporate debtor. The amendment of 2018 also altered section 60 in that insolvency and bankruptcy process relating to liquidation and bankruptcy in respect of three categories, that is corporate debtors, corporate guarantors of corporate debtors, and personal guarantors to the corporate debtors were to be considered by the same forum. Now, while this was reiterated, the fact remained that the partnership firm or partners of the partnership firm who will also become liable not were to be dealt with only by the DRT in terms of section 78 of the code, which is part of part 3. Now, section 2, that is application provision of this code in relation to different entities as originally enacted did not contain a separate category of personal guarantors to corporate debtors. Instead, personal guarantors were part of a category or group of individuals to whom the code applied. But they have again reiterated the same. The code envisaged that the insolvency process outlined in the provisions of part 3 was to apply to them. The statement of objects and reasons for the amendment bill, which eventually metamorphosed into the Amendment Act, stated that the code provided for the insolvency resolution for individuals and partnership firms, which are proposed to be implemented in a phased manner on account of the wider impact of these provisions. In the first phase, the provisions would be extended to personal guarantors of corporate debtors to further strengthen the corporate insolvency resolution process, and a clear enabling provision for the purpose has been provided in the bill. The amendment introduced section 2E, that is personal guarantors to corporate debtors, as a distinct category to whom the code applied. Now the amendment was brought into force retrospectively on 23/11/2017. Section 1 of the Amendment Act says so much, they have extracted all those things. Then 99. In addition to section 2, the same amendment also amended section 62. Interestingly, though personal guarantor was not defined and fell within the larger rubric of individual under the adjudicating authority for insolvency process and liquidation of corporate persons, including corporate debt and personal guarantors, was NCLT, even under the unamended code. The amendment of section 62 added a few concepts. This is best understood on the juxtaposition of the unamended and the amended provisions, but they have extracted these provisions. Then paragraph 100, not which speaks about the liquidation before the words of bankruptcy. Not these are all amendments which they have said. So this judgment not ultimately upheld the notification of 15/11/2019, which provided that a class of persons called as personal guarantors to corporate debtors would also be subjected to the provision of code and the adjudicating authority in NCLT. Now, having said so, my lord, in so clear terms, that it would never be open for anybody to claim that a partner of a partnership firm, by virtue of some document of indebtedness, to be treated as a personal guarantor, and therefore I will treat the partnership firm as a personal guarantor, which is precisely not what the other side is trying to bring about. Therefore, this judgment also in terms of the amended provision makes this clear. Now, with this, only two more submissions your lordship will recollect. Ultimately, they rely upon a document dated 16/11/2012, 6/11/2012. That is the only fulcrum of entire contention which they say. But which I pointed out your lordship earlier also, there is no such word as a loan. That was a simple stir agreement in respect of a land transaction where a particular advance amount was agreed to be treated in a particular manner. It did not specify about any loan transaction. The agreement also did not specify anything about guarantee. What the contention as well as the pleadings of the other side would be that, but once a person is a party to the agreement where there is some indebtedness which is being imposed upon, each of the other person will be a guarantor to the other. But this is their contention. Not to just dispel this, but I am relying upon two judgments. Only the oldest one. Compilation. But I have just circulated in the last occasion, ILR volume 15, page 949. Sir, can you just take out this copy? That is a case of RMMST, Vairavan Chettiar versus official assignee of Madras. Appellate civil before a division bench. but the head note itself, in the absence of a custom or contract to the contrary between joint debtors who are jointly and severally liable to a creditor, each is not a surety to the other as defined by Section 126 of Indian Contract Act, nor do they occupy a position analogous to that of a surety, strictly so called, so as to attract the provisions of Section 141 of Contract Act. So in terms of 126, the instant case, what they refer is that an agreement where two parties are the signatories. So basis of the two parties being signatories, for their convenience, they call the company as a corporate debtor. They tag the partnership firm as a guarantor. That is not is what permitted is the earliest judgment of the year 1955. Now just over the page, if your lordship sees page 951, second paragraph. We entirely agree with the learned judge. We entirely agree with the learned judge that the evidence does not make out any specific agreement between the parties to the effect that though as between Indian Bank and the debtors, they were jointly and severally liable, as between themselves, each should be regarded as a surety for the other in respect of his moiety of the debt. Under the Contract Act, the contract of guarantee is confined to cases where the guarantor agrees with the creditor to discharge the liability of a third party in case of his default. Cases where on the face of contract, two persons are both jointly and severally liable do not fall within the definition. In other words, the contract of guarantee as defined under Section 126 of the Contract Act is confined to cases of surety strictly so called. Though there are a series of judgments on this Section 126, I am not troubling a lordship. I will take a lordship to one of the latest judgment, 2021 2 SCC 799. Interestingly, which is also concerning the Insolvency and Bankruptcy Code. A case where, my lord, there was a pledge agreement. Basis of the pledge agreement, a claim was made that they are a guarantor, therefore I will proceed against them. But your lordship can directly come to paragraph 22, my lord. The fact situation is that basis of a pledge in respect of a debt, that a claim was made by filing a Section 7 application as if the company is a guarantor. Now, paragraph 22, where the corporate debtor owned any fish. Yes. And I will read from 23 itself. The learned counsel for the appellant in his submissions has relied upon Section 58I to support his claim that the appellant is a financial creditor. The learned counsel for the appellant has referred to both subclause B and subclause I and submit that credit facility which was extended to the borrower is referable to Section 58B, and the corporate debtor pledged his share to give indemnity for credit facility, and which is in the sense of guarantee. The debt is a financial debt within the meaning of Section 58I, and the appellant is a financial creditor. There can be no dispute that credit facility given by the assignor to borrower by the facility agreement is a credit facility which can be covered under Section 58B. A bare perusal of Section 58B indicates that it contemplates amount of any liability in respect of any of the guarantee or indemnity for any of the items referred to in subclause A to H of clause 8, subclause I, uses two expressions, guarantee and indemnity, for any of the items referred to in subclauses A to H. Chapter 8 of the Contract Act deals with of indemnity and guarantee. Section 124 defines contract of indemnity and Section 126 defines contract of guarantee. Section 126 is relevant for the present case as follows. Not provision is extracted that defines not what is a guarantee. Now paragraph 25. As is clear from the definition, a contract of guarantee is a contract to perform the promise or discharge the liability of a third party in case of his default. The present is not a case where the corporate debtor has entered into a contract to perform the promise or discharge the liability of borrower in case of his default. The pledge agreement is limited to so and so, it goes on the pledge. So these 3 points are the effective points which I sought to refer. Then your lordship will come to paragraph 28. The pledge agreement and undertaking given entered into between assignor and the corporate debtor cannot be termed as contract of guarantee. Paragraph 28. The pledge agreement and undertaking given entered into between assignor and corporate debtor cannot be termed as contract of guarantee within the meaning of section 126. The expression pledge, they go on. Then 30, paragraph 30, the words guarantee and indemnity as occurring in section 58(1) has not been defined in the code. Section 3, clause 37 of the code provides that words and expressions used but not defined in the code but defined in the Contract Act shall have the meaning respectively assigned to them. Therefore, not reading into that, ultimately what the Honorable Supreme Court held in this judgment is that not a reading of section 126 makes it clear that there would be a promise by a person to a liability of other party. And in absence of any such document, there cannot be construed as existence of any contract of guarantee. Because ultimately, the personal guarantor definition would say that an individual who stands as a surety under a contract of guarantee. So none of these stand satisfied. I'm not troubling your lordship again. Your lordship will recall the so-called petition filed by them before the NCLT is only on the basis of this agreement. And they try to read into saying that therefore there is a personal guarantor and therefore there is a personal guarantee and therefore a petition is maintainable. And ultimately, as I pointed out, it all boils down to the point that basis of this, the very next day, there is a filing of a memo claiming that there is a moratorium, therefore you stop the arbitration proceedings. And as I again reiterate that this was not an individual incident. They had been repeatedly under different guise, taking a plea that the arbitration shall not proceed with. Therefore, there is absolute and mala fide intention insofar as this filing. And therefore, we have come before this honorable court so that your lordship will exercise the power of judicial review to hold that the very petition is an void instance. But I have circulated all those judgments. I will not trouble your lordship again as to the scope of judicial review as well as certiorari and prohibition which you have sought for. I am grateful, I will file a written submissions by Monday,
By
Just
Monday.
recapitulating, I will just circulate it to the
By
court.
Monday, you give to.
Yes,
Give copy to other side.
yes, I will serve the copy.
My lord, I had two submissions, my lord, two-line submissions. With regard to the judgment which is being produced by learned senior counsel, that Lalit Kumar Jain, that is being discussed in Jivraj Ka case, and the Jivraj Ka case has come into being passed after discussing the judgment. Subsequent judgment wherein they rely on the 126 guarantee. The petition was invoked before NCLT itself. Now the question is, my lord, whether under a writ jurisdiction, this court can enter into the factual aspects and decide the questions, my lord, which is being argued by us extensively. We'll also file the written synopsis by Monday, my lord, circulating the copy to the others.
You will also file on.
We'll also file a written synopsis.
Notify on Monday. No. Or learned there.
Please, ma'am.
Near
Anish
council,
Acharya.
Mr. So and so, so and so. Nish.
Nish Acharya.
Assist by so and so for the appellant and learned. Senior advocate Mr. Prakash with learned advocate so and so for the respondent. Only one respondent.
Yes.
At length, learned counsel for the party stated that they argued the appeal. Finally, they further stated that readings are complete and no further are required to be added or supplemented. Resort for judgment.
I'm grateful for your lordship's patient hearing. It has been a very good learning experience going through the various judgments. Oblige me.
Pardon? You give by Monday.
Yes, we'll circulate it.
Can be complete.
We'll furnish by Monday.
At the name of central government, also so and so, it is state central government. At length.
Yes, number 92.
Yes.
Ram Shiv Prakash.
Yes. Yes. But on the last occasion, I was referring to 3 notices issued by them.
Three notices.
3 notices, yes.
So which are the dates? Give the dates.
Please, Milord.
Dates.
Dates, yes. But the division bench judgment came about on 31/8/23, stating that the tenure is 14/11/24. And any action that has to be taken on an inquiry could be taken in accordance with law. Before this 31/8/23, they had issued 2 notices dated 14/7/23 and 27/23. Yes. In the 14/7 notice, they said that one member secretary was illegally appointed. They cast the blame on me. But they had not issued this notice under the Water Act, stating that for removal under the Water Act. Similarly, they issued a notice dated 27/23,
27,
stating that
27 or 23.
27/23, July 20th, 23. Stating that one Enviro Clean company had been granted certain work orders. And even this notice was a cryptic notice of 1 para, not issued under Water Act.
Not issued under what?
Under the Water Act 6E, my lord, where 6E provides for removal. It was a general notice asking me to show cause. Then, my lord, these 2 notices were before the division bench judgment. These 2. After they suffered a loss before the division bench judgment, they concocted certain other allegations and issued a fresh notice dated 26/12/23. Sorry, 29/12/23.
29/12/23. Now you are dismissed pursuant to this notice.
I am dismissed. Actually, they raised all the 3 allegations against me. The order says I am liable for not having shown cause for all the 3 notices, out of which 2 are not under Water Act. Therefore, my lord,
No, your dismissal is based on all the 3 notices.
only 3 notices, 3 allegations. Yes. The Water Act, I'll just 6E Water Act. 6G, Lord. 6(1)G. No person shall be a member of the board who has so abused in the opinion of the central government, or as the case may be of the state government, his position as a member as to render his continuance on the board detrimental to the interest of the general public. Therefore, my lord, one is the abuse must be of such an extent that it should be detrimental for me to continue with the position. That was the standard. Now, my lord, for a moment, just to unclutter make it more simpler, my lord, bring in more clarity in my arguments. Kindly see page 118 of the paper. Page 118. Translated copy is at 123. Translated 120. Translated copy. Pagination's problem. Yeah. 124 is the pagination. Sorry.
Inquiry was not held.
Please, Mula.
No inquiry was held.
No hearing. They just took my show cause, my lord. Reply. They just took my show cause and then went ahead and passed the orders. No fundamental inquiry.
Even charge sheet is not.
Not.
Framing of charges.
Nothing. These were given to me, my lord. They asked me to reply. I replied.
And you are dismissed.
Then they abruptly removed me from office. In fact, after my reply, they kept it pending for 5 months. At least after my reply, my lord. My reply was in January 24. They dismissed me on 35/24. 5 months, they keep it pending. And in this interregnum of 5 months.
When you are dismissed?
35/24.
30th/5.
35. 305. May 30th. 31st, sorry. 31st. 31. Now, my lord, out of these 3 allegations, which they hold out against me, one is member secretary, just these 3 allegations. Second is enviro recycling. And third is tenders given in respect of environmental awareness program to certain companies.
Who you are appearing?
Learned AG is appearing.
In fact, my lord.
Some malpractice in tender.
That I have given the tender to certain organizations. Those organizations held monopoly in respect of bus hoardings, in respect of KSRTC department. They had this contract with the KSRTC department. I gave them. But actually what happened, I'll just show to your lordship's blood. What they do is, they make 9 allegations against me. I give reasons for those 9 allegations. But they ultimately give findings on something other than 9 allegations. They abandon those 9 allegations. Give findings on different issues which were never put across to me. I'll be able to show your lordships. These are fundamental defects in natural justice. So that, Lord, if they had given these original allegations, what they gave in findings, then I would have replied to them. But they abandon it totally. Go to something else.
Where, in which not?
In the 3rd allegation.
In the 3rd allegation.
In the 3rd allegation. That is the tenders.
That is 29/12.
Yes, 29/12. And my lord, I'll be able to show you lordships. Just the first 2, my lord, will fall because it is not under Water Act. They have to say.
You answered 29/12/23 or not?
Yes, we answered 29/12. That, my lord, I'll just take your lordships through this. Kindly see, my lord, I have a translated copy because the translation that is given there, placed before your lordships, is not the exact translation. There are grammatical errors. So we got the AI translation, artificial intelligence translation, which is very perfect. Now, my lord, here, this is the order, my lord. It has page also. Yes. Not kindly see, subject is regarding disqualification of Shant Tamaya from position of chairman. Reg government notification. Now, my lord, here. The first portion is summary. Yes. Internal, the page number 3, my lord, part 1. Kindly see, at the bottom is part 1. This is the first allegation. Here it says regarding violation of provisions of Karnataka Transparency Act in the approval of programs organized by Karnataka State Pollution Control Board for creating awareness about environmental protection and pollution control board. Now, my lord, in this, kindly see the first allegation. I need not read this, my lord. It basically says The State Pollution Control Board violated provisions of Karnataka Transparency in Public Procurement in approval programs organized for creating awareness about environmental protection and pollution control. Additionally, by bypassing the Department of Information and Public Works, public relations, work orders were issued to private advertising agencies, leading to misuse of public funds and authority. In fact, no amount was released. Not even a single paisa was released by this chairman. Till today, no amount is released to these agencies. But they said misuse of public funds. Yes. Reports in the press and accepted complaints in the government have confirmed this. And considering the prima facie case, the government deemed it appropriate to conduct a detailed investigation to ascertain the truth of this misuse of authority and funds. Accordingly, as per Red Order number 1 dated so and so, Mr. Mahadev, Director, Karnataka State Audit and Accounts Department, Bengaluru, was appointed as investigating officer. After examining the responses, information and records provided by Member Secretary, Karnataka State Pollution Control Board, Mr. Mahadev, Director, Karnataka State Audit and Accounts Department, Bengaluru, submitted a comprehensive investigation report in 2 volumes. Then, in the year 2022, almost all announcements, Lord, all this can be left, Lord. Kindly see, Lord. The list of allegations are set out. What were the 9 allegations that were posed against me? Kindly see page 19. Page 158. Yes. Yes. Kindly see page 19 of this order. Though they make this order very elaborate, there were 9 illegalities mentioned in the notice. In response to the allegations mentioned in the government's notice, Mr. Shantatamaya has provided the following defense. That is me. What I did, I made out a table. I said, this is the allegation on the left side. This is my explanation. Lord, kindly see 9 allegations are set out. The first one is a specific supplier or contractor. Only when the supplier or contractor has exclusive rights concerning goods or services or constructions and no reasonable alternatives of it exists, should provisions of 4B of the Transparency Act be utilized. However, in the context where other entities are eligible and available for proposed advertisement contract methods, considering them as sole sources, so and so, so. Now, Lord, I gave for all the 9 allegations, they listed 9 allegations from page 19 to 24 are the answers to the 9 allegations. Please, page 19 to 24. After I answer these allegations, the findings are at page 25. Now, Lord, all the allegations relate to having selected certain institutions which had monopoly in that field by bypassing the Transparency Act. These were the general allegations. Now, Lord, kindly see the findings. Page 25, Lord, para 12, para 13. Even para 12, para 13 can be left. The last sentence in page 25 may be seen, where the authority, dismissing authority, terminating authority says, summarizes my reply. Kindly see the last sentence, Lord, in page 25. He has requested the government to withdraw the show cause notice, considering his explanation and defense, as the awareness programs were approved by the board meeting and there is no question of legal violation by the chairman. It ends there. Therefore, they extract my entire reply and reproduce it here and say, kindly drop the proceedings. Now the findings start from 26, para 14. Kindly see the findings. MSI Developer Advertisers has been considered a sole advertising agency by KSRTC, and the said agency has been approved by the Central Bureau of Communication, Government of India, with DAVP rates until 31/1/24 based on the approval dated 1/7/22. However, investigation has revealed the following facts. DAVP approval letter number so-and-so states rates are valid until 31/12/2021 or until further orders, whichever is earlier. Despite not obtaining a revised rate list, agency was considered a single source. But this allegation and all the allegations here are never put in the show cause. This allegation And all the allegations here, findings held out against me, are never put out in the show cause notice. In the show cause notice, they must say that these were the rates. The rates were valid only till this date. Why did you approve it?
Which were the allegations not part of so called?
Nothing.
No,
This entire findings in paragraph 14, 1 to 14.5, none of them are in the show cause notice. Show me the translation. Kindly see the show cause notice, page 161.
Any of the so called notice?
Nothing, none of them. In any of the show cause notices. Please, stand correct. The findings with respect to Sai Advertisers Agency from para 14 subpara 1 to 5 are not part of the show cause notice at all. I have never been asked to answer these allegations. But for that, kindly see the just page 161, one page, 161, which is the show cause notice on this issue, which I had been asked to, 29/12/23, translated copy. Yes. At page 162 are the allegations. Yes. It is clear from the investigation report that you have misused your position and authority and committed the following irregularities and misconduct by violating the provisions of the Karnataka Public Procurement Transparency Act 1999 in activities undertaken to create awareness, awakening about environment protection and pollution control. Number 1, Section 4B of Transparency Act should be used in a particular purpose, supplier or contractor. Number 2, constituency of committee for selection of single source organization agency. Number 3, yes. Number 3, acting contrary to the authorities designated rule 15C of the Karnataka State Board for Prevention and Control of Pollution and Water Rules 1976 and willfully violating the rules. Number 4, advertised without technical sanction and administrative approval of member secretary for violating the provisions so-and-so of the Karnataka State Board for Prevention and Control. 5, misuse of power by violating Rule 15E of the Karnataka State Board for Prevention and Control of Water Pollution and Water Rules by accepting a tender amounting to more than 7 crores. 6, although it has been mandated in, yes, 6, yes. Although it has been mandated in Karnataka government's amendment order to issue all advertisements of all government corporations and boards through the Department of Information and Broadcasting, through the Department of Advertising Policy, advertisement has violated the government's policy. Failure to enter into contractual, 7, failure to enter into contractual agreement with all institutions considered as single source institutions. 8, dereliction of duty by issuing work orders in absence of DAVP tariff. 9, adequate supervision of advertisement broadcast publication work by the organizations causing failure of the objectives of creating awareness among. Upon confirmation that the incumbent chairman of the State Pollution Control Board has misused his position and authority by committing violations of rules, dereliction of duty, misconduct and irregularities under Rule 61G, the Karnataka State Board for so-and-so is directed to submit a written explanation. This is the only show cause notice. Now, my lord, kindly, if we contrast this with page 28 of the order, the translated copy which I provided, these were general allegations on the rules and violations which were put out for me to show cause. But see the findings, blood. From where they can get these findings? Page 28 of the translated copy which I produced, blood, by a memo to your lordships. Yes. Here it says, the letter number so-and-so from Central Bureau of Communication, Ministry of Information Broadcasting, Government of India mentions extending current rate till 31/12/24 for 106, sorry, Mlad, I'm sorry, Sai Advertising, page 26, Mlad, I'm sorry, page 26. Sai Advertising has been considered a sole advertising agency, page 26, by KSRTC and KKSRTC, and the said agency has been approved by the Central Bureau of Communication, Government of India, with DAVP rates. Number 1. However, the investigation has revealed the following facts, making the defense unacceptable. Kindly see, Mlad, 14.1 14.1 may be seen. No? The DAVP approval number dated so and so states the rates are valid until 31/12/2021 or until further orders, whichever is earlier. Despite not obtaining a revised rate list, agency was considered single source. This was never put out, not this allegation. Then Lord 14.2, as per decision of the single source committee, Sai advertising was considered as single source and approved for an advertisement contract worth of 3.4 crores. However, as per letter of the chief tariff manager of BMTC, advertising rights on 200 Vajra buses were granted for a period from 1/3/22 to 28/2/23 with a monthly rate of 35,000. This was also not put out. Despite this, the investigation revealed agency does not have sole rights with BMTC. No DAP rates were provided. This raises doubts about consideration of the agency as a single source. All these allegations, I need not read it, but I have read it through and through. Whatever was referred in the 29/12/23 notice, none of those points are there. Certain new points have been added, totally new points. And findings have been given. This runs to para 15 also. Next page. At para 15. Subclause 1, my lord, at page 28. This is so far as Signpost India Limited. Letter number dated so and so from Central Bureau of Communication, Ministry of Information and Broadcasting, Government of India mentions extending current rate list until 31/12/24 for 106 outside media, 106 outdoor media agencies. Considering that Signpost is one of these 106 agencies, it cannot be considered as a single source. Advertisements must be displayed in 200 bus shelters in Bengaluru. The total amount payable, including none of this is referred in the original showcase. Then, my lord, kindly see 16, MS Adorno Private Limited. Here also, they go into the nitty-gritties of these minor details of these contracts, which none of them were placed as a reason of violation for. Finally, they come, Lord. Kindly see, page 29 may be seen. All from para 16.1 to 16.7 are all relating to Adorno. Lord, the whole thing is, Lord, in order to somehow or the other remove me, new allegations are raised against me, foisted against me, and findings given without an opportunity for me to show cause. Then, my lord, kindly see page 31. Lord, on this point, Lord, I'll just pause here a moment. The Supreme Court has time and again said as to how inquiries must be. One paragraph, a recent judgment of the Supreme Court. Para 13. Recent judgment. Shall I read, not para 13? At the outset, it must be noted that it is the first principle of civilized jurisprudence that a person against whom any action is sought to be taken or whose right or interests are being affected should be given a reasonable opportunity to defend himself. The basic principle of natural justice is that before adjudication starts, authority concerned should give to the affected party a notice of the case against him so that he can defend himself. They have not even whispered about these allegations at any point of time prior to the date of findings. Then such a notice should be adequate and grounds necessitating action and penalty or action proposed should be mentioned specifically and unambiguously. An order traveling beyond the bounds of notice is impermissible and without jurisdiction to that extent. This court in Nazir Ahmad was assistant custodian evacuee property, Lucknow, has held it is essential for the notice to specify the particular grounds on the basis of which an action is proposed to be taken, so as to enable the noticee to answer the case against him. If these conditions are not satisfied, person cannot be said to have been granted any reasonable opportunity to be heard. Specifically in the context of that's the different part. Therefore, my lord, very clear, absolutely clear that they have trumped up new allegations, new findings, all of which was never part of the original case. Now, my lord, kindly see para 20 and 21, page 31 of the showcase. After, so my lord, 14, 15, 16 are new allegations. Para 20 is where they give one more finding. Shanta Tamaya has not provided a satisfactory defense regarding issuing advertisements without technical and advice. Shall I read that? Yes. Yes, ma'am. Shanta Tamaya has not provided a satisfactory defense regarding issuing advertisements without technical and administrative approval of the member secretary, violating sub-rule 16, 6, 8, and 11 of the Karnataka State Pollution Control Board, and so and so. As per Rule 15A of the Karnataka State Pollution Board for prevention and control of pollution, transaction of business and water prevention control rules 1970, chairman has the authority to approve tenders up to the value of 25,000. However, by approving tenders exceeding rupees 7 crores and issuing work orders, Shanta Timaya has clearly misused his authority. Now, my lord, on this, I had given a reply. It said, basically it said that technical member, the member secretary should give technical and administrative approval. You have proceeded, I have proceeded without the approval of the member secretary. Kindly see my defense to this. That defense itself has not been considered. Page 21 of the same order, they extract my defense and my answer to this allegation. Page 21 of the same order. Previously. Of that same order, page 21, bottom portion. Yes, kindly see allegation 4 at the bottom. Issuing advertisements without technical approval and administrative sanction of the member secretary. That was the allegation at para 20. Violating sub-rule 16, 8, and 11 of the Karnataka State Pollution Control Board and control of water pollution and water prevention. For this, my answer is at the right side, bottom. As per Rule 16.6 of the Karnataka State Board for Prevention and Control and the Water Prevention 1970, it is stated that member secretary shall be subordinate to the chairman and shall be subject to the control of the chairman. Furthermore, member secretary has participated in all the stages of process of issuing directives to the institutions for the said advertisement. Additionally, directives have been issued to 3 institutions by the member secretary himself. Therefore, there is no violation of Rule 16.6. Furthermore, 16.8 pertains to. Lord, even this defense is not considered. While concluding at para 20, Lord, while concluding at para 20 against me, my defense itself is not considered. My defense held out as to show where the member secretary participated while giving the tenders. And all directives were issued by the member secretary. Without considering that defense, they come to the conclusion. Therefore, my lord, there is total non-application of mine in the conclusion at para 20. Now, my lord, kindly see para 21. Mr. Shanta Timaya, kindly see 21, my lord, para 21. Mr. Shanta Timaya has not provided any information regarding any urgent circumstances faced by the chairman to take immediate action to issue advertisement exceeding the estimated expenditure without the board's approval, administrative and technical. Therefore, the likelihood of misuse of authority of Shanta Timaya is highly probable. Lord, this was not an allegation at all in the 9 allegations. That urgent measures were taken to issue the advertisements, they never put it out to me. This was not an allegation at all. Then will not kindly see para 22. After the first meeting of the single source committee, approximately 15 days were taken to issue work orders based on the proceedings of this committee. Although tender process could have been completed within an estimated period of 35 days, decision taken based on the aspect that same single source method has been adopted in other organizations is unacceptable. Even this was not an allegation. There was never an allegation which said, you should have taken the 35 days route. Why did you take the 15 days route? There was never an allegation. Finally, kindly see para 23. Despite the mandatory requirement for all corporations, boards within government's scope to release advertisements through the Department of Information and Public Relations as per Government of India, Government Advertisement Policy 2013, Karnataka State Pollution Control Board has independently issued advertisements violating the government's advertisement policy. The justification provided by Shantamaya that Karnataka State Pollution Control Board is an autonomous body and does not receive any grants. Hence, advertisements were issued directly cannot be accepted. Therefore, it is confirmed that Shanta Timaya has misused this authority. But even this, whatever the finding is given at para 23, my defense has not been considered. I had stated, kindly see, Lord, at page number. Kindly see page 22, allegation 6. Even that defense is not considered. page 22, allegation 6. It says, despite mandatory requirement for all corporations and boards under government to release all advertisements through Department of Information and Broadcasting as per Advertisement Policy 2013 and as per government amendment, the board violated the government's advertisement. For this, my answer was, the State Pollution Control Board operates independently without grants from the government. Various government departments and corporations have been issuing advertisements separately for many years. Some advertisements are also issued directly through government-owned MCA institutions for many years. Lord, all these replies are not even considered. There's total non-application of mind by the authority. Minimum, Lord. The minimum that was expected from the authority while issuing an order as serious as a termination order or a disqualification order was that they consider this. They do not consider this. Therefore, Lord, this, so far as part 1 is concerned, 29/12/23 notice, that part 1 notice is concerned, one, the points of law, if I may succinctly frame the points of law for the part 1 part of the notice is, one, that the findings are on allegations which were never put across to me. From para 14 to 16. The second is, original allegations are abandoned and new allegations are framed in the order. Third is, the findings at para 20 and 23 in part 1 are without application of mind because my defense is not considered, not even referred to. And lastly, the findings in para 21 and 22 were not part of the original allegations.
Were not part of?
The original allegations. Yes. Yes. Now, Lord, I will just take one minute so far as part 2 and part 3 is concerned, because on technical grounds it has to go. Part 2 allegations is on the appointment of Suri Payal as member secretary. They held out that that appointment was illegal and therefore they brought it within this dismissal order under the ground of abuse of power. Now, Lord, if that Suri Payal original notice were seen, that is at page number 123, the first volume. Just 1 minute. That issue. 124, correct. Reply. Show cause notice blood is at 116. 116. It says 116 blood, show cause notice, 116, sorry. Sorry. Annexure H. This is 27/23. Yes. Here, my lord. it just says, kindly see, your act of deliberately disregarding the rules of government, page 118. Your act of deliberately disregarding the rules and government guidelines and acting in an unauthorized manner is questionable. Therefore, you're requested to submit a written reply and explanation within 1 week of receipt of this notice regarding a questionable and unauthorized. Nothing was put out to me saying that this is an abuse of power under Water Act, as contemplated in the Supreme Court judgment, which I pointed out. What is the specific charge and what is the penalty that I would incur? That is not stated here. Therefore, my lord, the part 2 allegations would collapse because it is a vague notice. And this part 2 allegation is used as an afterthought in this 31/5/24 notice, termination order. Because it was issued some time back. I issued a reply. They forgot about it. Suddenly they have raised it in this, added to this termination order. Now, my lord, kindly see part 3 notice. That is at page number. Before going to part 3, my lord, I'll just point out the page. Page 132, maybe see. It is at 138 exactly. This is the third allegation against me. Yeah. It says, according to the notice issued by Central Pollution Control Board, dated 24/11/23, is instructed to take specific measures regarding violation of plastic management rules, so and so. However, even though the Honorable Departmental Minister in Belgaum is instructed to take immediate action regarding non-implementation of directions of the said letter on the behalf of the board, as the said case is of a serious nature, you have failed as chairman of the board, the Karnataka State Pollution Control, by not taking action. Here, not. Then kindly see page 139. It says, providing information along with supporting documents about the number of cases pending in Karnataka State Pollution Control Board for the last 2 years in which prior approval of the government has been obtained. Otherwise, regarding the said omission, I am directed to submit their explanation in writing within 1 week to they say, submit explanation to the Additional Chief Secretary, Principal Secretary, Forestry and Environment Department of the government within 1 week of the receipt of the notice, asking the reason as there is no. So, I was asked to give a reply to 3 officers, different officers. I gave a reply to 3 different officers. One is this, none of this allegation said it is under Water Act. Second is, I gave 3 different officers I've been asked to reply to. But how can that notice to 3 different officers? I'm asked to show cause to 3 different officers. How can this officer take it as a ground in his termination order? Now, Lord, in conclusion of that termination order, kindly see, Lord, one of the most unacceptable part of this termination order is where they discard the right of hearing totally. Kindly see page 43, Lord, before the order of termination.
Page
40, page 42, para 6. Translated, that copy, memo copy which I produced, the correct translation. In that page 42. Yes, Lord. In the interim order issued on 22/2/2023 in writ petition number so and so, Honorable High Court, noting the necessity of board officers, issued a stay of suspension. That also can be left. Kindly see, Lord, 43. Regarding the consideration of being 43, top from. Regarding the consideration of being public servants under section 50 of the Water Act, the members, officers, employees of the Central and State Pollution Board are deemed to be public servants. They extract 50, that can be left. They extract section 50, we can leave that. Kindly see subclause 3. In the case of S.L. Agarwal versus General Manager, Hindustan Steel, The Honorable Supreme Court held that the position of the chairman of the State Pollution Control Board is not a civil service position, and Article 311(2) of the Constitution of India does not apply to the removal from the board membership. Therefore, my lord, they say natural justice is not. Now, my lord, legally speaking, 311 may apply to a civil service post, but elementary principles of natural justice of showing cause, issuing a charge sheet, and conducting inquiry based on a charge sheet will apply in normal circumstances also. Then Shanta A. Tamaya was such as, while serving as chairman of the Karnataka Pollution Control Board, deliberately refused to implement provisions of so and has abused the powers vested in him under Rule 16 by acting beyond his authority and misusing public funds approved for awareness programs of environmental protection and pollution board by the Karnataka State Pollution Control Board, violating the provisions of the Karnataka Transparency in Public Procurements Act on the facts detailed in Part 1 and abuse of discretionary power detailed in Part 2 and 3. Government has ordered following, recognizing that its continuation in the position is detrimental to the. This very clearly stated. I will take your lordships through only one judgment of the Supreme Court, where the word abuse of power has fallen for interpretation, and a circumstance where it is 2016 SEC 260. Open that entry. 1 second. Just open that entry, which is the judgment. Open the 2000. Mm-hmm. 2001, 2001, 6 SEC. This one. Where is this? In the copies. Copies. That's the judgment. What? Yes. Second call. Yes. Yes, but kindly see. Yes, but para 7, I will read. Para 7 of the judgment. 2001 6 SEC 260. Yes. In a democracy, yes, para 7. Here it related to an elected person, but nevertheless, removal from office was considered. Shall I read? Bro? Para 7.
Yes, who is?
I will just refer to only one thing in that.
Yes.
Kindly see para 9, bro.
There are 9.
I will not read it.
That you read.
Yes. Abuse of power as providing a ground for proceeding under section 22 is not defined, is in the act. Black's Law Dictionary gives the meaning of abuse as to depart from legal or reasonable use in dealing with to injure physically or mentally, to damage in corpus, so and so, my lord, all that is considered there. Then, my lord, kindly see, 11, para 11. The expression abuse of power in the context and setting in which it has been used cannot mean use of power which may appear to be simply unreasonable or inappropriate. It implies a willful abuse or an intentional wrong. An honest, though erroneous exercise of power or an indecision is not an abuse of power. A decision, action, or instruction may be inconvenient or unpalatable to the person affected, but it would not be an abuse of power. It must be an abuse of power which would render a councillor unworthy of holding the office of president. Inasmuch as an abuse of power would entail adverse civil consequences, the expression has to be narrowly construed. Yet again, the expression employed in section 22 is abuse of power, so and so, so and so. Now, my lord, apart from this, I would just refer to one point, para 12. One of the requirements of the principles of natural justice, where that is elaborated. Lord, this was also a case where original allegations were different and findings were different. One of the requirements of the principles of natural justice incorporated in second provision, section 22, is that reasons for the proposed removal have to be communicated to the person proceeded against. The purpose of such communication is to enable him to furnish an explanation of his conduct or his act or omission, which is likely to be construed as an abuse of power. It is clear that the facts constituting the gravamen of the charges have to be communicated. It follows as a necessarily correlation therefrom that what has not been communicated or not relied on in the show cause notice as a ground providing reason for proposed removal cannot be relied upon as furnishing a basis for the order of removal. That is at para 12. The person proceeded against under section 22 of the Act has to be made aware of the precise charge which he is required to meet, and therefore he must be apprised of the exact content of the abuse of power attributed to him. The authority taking decision must apply its mind also to the explanation furnished by the person proceeded against, and this must appear by the order passed under section 22. Therefore, all that section para 12, every principle of law enunciated under natural justice in para 12 applies to this case, because they took some other allegations, they never proposed original grounds, and never considered my explanation. And they were applied their mind to the explanation furnished. And they were also not clear as to what was the abuse of power in the first two notices. Therefore, Lord, I pray that the order be set aside, and this was a malified action where the government, as is evident, only with the intention to victimize. And the whole pattern of the effort made against this petitioner, Lord, is that first they tried to truncate his tenure, cut short his tenure and remove him. When they did not succeed, they trumpeted charges and they are trying to remove him. Therefore, Lord, this is an instance of gross abuse of power by the terminating authority or removing authority, and therefore the order deserves to be set aside and his office be restored. That's my prayer. Please.
Replay.
And it is only till November 14th, Lord.
Today you are out of service.
Please, Lord.
Today you are out of service.
Today I am out of service.
Ashna, kindly have it next week for replay by age.
When learned advocate general would come?
Week after next. Week after next.
Week after?
Yes.
That will be too late.
Lash, may kindly have it on 26th or 29th.
That will be too late.
24th.
24th.
20.
Please.
Okay.
Please.
Now subsection 2 of section 6 of the Water Act. Unless the member concerned is given a reasonable opportunity to show in cause. So does it contemplate a full-fledged inquiry or not?
Yes, that's.
That I will flag.
And that is one of the questions.
Please.
And you stigmatize somebody. Yes. That you need to hold the inquiry.
Yes.
Please, please.
So 238.
Please.
230.
Any matter is kept on 20.
This is
24.
Please.
Next item is, my lord, is minimum wages issue, my lords. I beg to appear in very next. This is a statewide minimum wages issue of the laborers. Next item. In early. Yes.
My lords, I appear for the appellant.
Yes, minimum wages, my lord.
93.
93. We will no time today. Let us see. This can go to 23rd. 23rd. There will be no time because. Yes.
23rd of this month.
23rd, any matters I get. Sorry, 24th.
24th, okay, 24/7.
Yeah.
25th.
At 2:30 minutes. That's it, 2:30 minutes.
2:30.
2:30 minutes. Yes.
Please, man. Grateful.
Very modest. Much.
23rd at 2:30. Okay.
24th. 25th.
24th, sir. 25th, sir. Till number 12.
26.
Delay of about 27 days, my lords, in this matter. We filed an IA to condone the delay of 27 days in this matter, my lords, a matter pertaining to the appointment of special public prosecutors to the POCSO court, my lords. There's a delay of 27 days, my lords.
Notice.
And it,
This renewal on 19th August.
sure, my lords, could we get a slight shorter date, my lords, because it pertains to appointment of special public prosecutors for the POCSO case.
13th August.
Please, my lords, deeply obliged.
Lord, I take notice for respondents 1 and 2.
1 and 2.
Obliged.
13 agents, number 14.
Yes, my lord. The contempt, the complainant herein, the brief facts of the case is, my lord, at the request of the president of the society, the complainant has surrendered his registered site bearing number 259B, measuring 50 into 80 feet, 4,000 square feet. The housing society at that point of time he has surrendered for the purpose of construction of the temple. In pursuant to that, they have undertaken to register the same land in the society, my lord. The society has undertaken the same to comply the order, but nothing has been done. As a result, the order at the time of order, the complainant herein was got impleaded in the writ petition number 994 of 2002. The impletion as allowed and they have undertaken to comply the order, the allotment of the site in favor of the complainant within 2 weeks, but nothing has been done. As a result, the petition, the complainant herein has filed a complaint before this honorable court, and he has given several representation to the society and authorities for considering the 1,200 square feet of the land site in his favor, my lord.
What about order dated 9/2/24?
Yeah, it is. The order is the 20, the limitation is only 1 year. This court in the full court has decided with respect to this, my lord, I'm relying on the clarification has been sought. The clarification has been sought, this honorable court in the full bench I may straight away go to page number 14, para number 14 and 15, my lord. Para number 14, 4363 page number, my lord. The 14, I may be permitted to read the 14 and 15 of the judgment, my lord. Dealing with this question, a learned judge of the Calcutta High Court observed thus in the Tata Iron and Steel Company Limited versus Ramnivas Podar Supra, I accept the submission of Mr. Somnath Chatterjee and hold that 1971 Act cannot define, limit or regulate the High Court's power under Article 215 to punish for contempt of itself. Similarly, Section 15 and 20 are ultra-vires Article 215. Section 15, however, can coexist with the summary powers of the High Courts only as an alternative additional procedure. So far, Article 215 is concerned, and non-compliances thereof will not affect the High Court's power to punish 1971 Act. Also can coexist as laying down the law for contempt of courts subordinate to High Courts. And it is categorically observed the article section 20 is applicable only to the section subordinate courts, not to the High Court. It is incongruent with Article 226 of the Constitution and 215 powers. 215, my lord. Under these circumstances, the notice may be directed on the respondents, my lord. The
I'll take notice.
Notice. Learned advocate, Mr. So-and-so relies on decision of the full bench of this court in Messrs. A.V. Cody and Company versus R.V. Lakshmi Devamma, ILR 1994-355 to submit that the limitation of 1 year contemplated in Section 20 of the Contempt of Courts Act 1971 is limited to the orders brought under contempt from the subordinate courts, and that when the contempt application is also filed under Article 215 of the Constitution, the powers are unfettered, not bound by period of limitation. Full stop. Notice returnable. 20th August.
I make one submission. Serial number 36, my. Serial number 36, my lord.
What is it about?
That is about, my lord, contempt matter, wherein, my lord, the municipality has directed to give the drainage connection to the, my lord, the canteen. However, my lord, he has made a reply that I can't give that. And one more contempt letter he has been issued to, my lord, against the order of the honorable court, my lord.
I will give for the
19.
I entered appearance yesterday. I'll file objection and also filed a review of the same matter order.
19th August.
Serial number 54, your lords.
My lord, one urgency is there, my lord. My lord, urgency is there next week, my lord, because my lord, the problem is, my lord, from last 4 months, canteen is stalled in the nearby, under the woman empowerment, my lord, she has opened the girl. So that, my lord, from last 4 months, it was earlier, it was in connection, my lord. Later, my lord, it has disconnected. The whole problem is, my lord, the canteen is, my lord, now it is stopped.
canteen, no business, my lord. My lease period is 5 years. Out of that, 4 years in the litigation only, my lord, regarding the, my lord, this type of trouble given by the, my lord, authorities. So that, my lord, next week, my lord, that's what, my lord, your lordship has made an emergent notice order for today for reply. However, my lord,
He is appearing.
he is appeared, my lord, but my lord, he has.
Filed a review petition, my lord. Today, the notice has been issued to him. Because it's impossible order, my lord. I have to cut across to a private land. That cannot be done by a municipality.
But there is no stay order in the review, my lord. What I
19th we'll see, yes.
please, my lord.
Serial number 30, emergent notice was issued to A1 to A3. A2 has entered appearance, A1 and A3, they have not entered appearance.
Wait.
My lord,
Serial number 42 and 43, my lords. Our application, based on the notification was dismissed, my lords, but the government-wide order, it has been made as saved application. So it may be heard in next week.
My lords, serial 68, party in person for reinstatement and de novo, spending since 1.5 months.
30th. 30.
Serial,
30.
30th, obliged.
serial number 54, your lordship. 54, your lordship. It is, the notice is complete, my lord. It was a case where the customs department had presented an appeal as against the order of quashment. Your lordships had posted it in the couple of weeks earlier, my lord. It was not listed. Now, my lord, since the very quashment has taken place, the accused person may.
Get the date from the court officer.
Well,
Yes,
serial number 18, my
Monday
lord.
or Tuesday, your lordship.
Monday.
Because if he runs away from.
All right, Monday.
I'm
Serial
grateful.
number 18, your lordship, education matter, my lords. University has approached Apex Court, my lords. SLP is dismissed, my lords. I had filed IA for appearance in the
You
exam.
mentioned yesterday also.
Please, my lords. It is listed, my lords, but not reached, my lords. Monday, my lords. Exams had already commenced from 15/7, my lords. He had already missed 2 examinations.
Exams will commence.
Commenced, my lords, from this month, Monday, my lords, from last Monday, 15/7, it was already.
Lords, I represent you. I represent you sitting there.
It is a contempt petition.
Please, my lords.
Contempt petition is
Writ
filed.
petition was allowed. My lords,
Yes, sir.
subsequently they-
Right.
Permit them to.
Yes, last occasion, my lords, I took time on the ground that we have filed SLP. SLP is dismissed. And the direction is to reevaluate the paper. The single judge direction is to reevaluate the paper, for which we are doing at a process. On Monday, we are going to declare the result. That's what I have said.
They
Second,
are going to.
declare the result. The direction of the single judge is that to reevaluate the paper.
Please, my lords, subsequent
My
academics,
lords,
my lords.
that is the direction of the single judge. We are already done the reevaluation. We are going to declare the result on Monday.
Had filed IA, my lords, for subsequent academics.
We'll
yours.
record the statement and keep it on Monday.
Please.
Yes.
Please, my lords. This
Monday or Wednesday.
Monday, my lords.
My lords,
because exams-
my lords, petitioner examination start, that also I secured instruction. So far as the subject is concerned, 25th is the date for examination.
20.
25th,
Then we keep it on 24.
yes. Grateful.
We record a statement.
Please, my lords.
Learned advocate, Mr. So and so makes a statement, people record that the university is going to declare the result
Result within 2 days.
of the complainant
Yes,
within 2 days.
Yes.
Pursuant to the re-examination of the answer sheet.
yeah, no, reevaluation.
Re-evaluation of the answer.
Yes.
In that view, awaiting the outcome, stand over to 24th,
Yes,
24th,
grateful,
to be listed at 2:30.
grateful.
Please.
Serial number 81. Serial number 81, the contempt proceeding, not the court of the director to not the relieve not the interim order. Still there is a relief, Lord. There is a.
Get some date. Get some date, yes.
My lord, serial number 40, my lord. A date in August may be provided, my lord. It is with respect to shifting of the boundaries, my lord, of Madheshwar.
My lord.
Your choice.
Serial number 50.
Date of your choice, get the.
Serial
My
number
lord.
50, my lord. A contempt matter arising out of the same matter has been listed on 7th August, my lord. On that matter, my lords was pleased to say that this writ appeal may be connected with that and listed on 7th August, my lord.